And otherwise is to, my lord, say that no, I don't avoid the transaction, I accept the fraud. My lord, if today you, my lord, seek to claim damages on account of fraud, then, my lord, you seek to avoid the transaction altogether. My lord, he has claimed damages. Now, my lord, here, if your lordship sees, my lord, the prayer G is damages for the sum of 10 crores against the defendant numbers 1 to 5 jointly.
Show us the impugned order.
Now, my lord, impugned order.
Memo.
My lord,
29th April.
yes, man.
You have admitted that the plaintiffs have contributed rupees 3.95 crore to LLP as long-term borrowing.
My lord, there is no such admission made. My lord, in the course of arguments, I, my lord, cannot vouch for what happened in Jalpaiguri, so I'll not make a statement, my lord, which might be otherwise, my lord, contrary to the facts. But, my lord, yes, some money has come into the firm. Without my knowledge, if, my lord, money has come, money will be paid back.
I'm only wondering whether prayer A of the plaintiff is maintainable.
It is not, my lord. It is not.
If it is not maintainable, interim order has to go.
Has to go. My lord, three things. Number one, my lord, you cannot, my lord, seek to set aside an award in a civil suit, which is, my lord, not a proceeding under section 34. Two is, my lord, the agreement is sacrosanct, and if the agreement says without the consent of all the partners, you cannot induct any third partner, then, my lord, the induction is bad. Three is, my lord, it says you cannot assign your right in the partnership without the consent of all the partners. So you can't transfer your shares. My lord, so therefore the purported sale is bad. If any money has come in, the money has come in as by way of loan, and if my learned friends are entitled to refund of the loan, they will get it. But that does not give him a right to, my lord, seek management of the firm also because of section 42. And, my lord, finally, damages. My lord, if today you have claimed damages, saying that this is a product of fraud, then you can't seek performance of the contract. If you can't seek performance, you can't ultimately seek interim reliefs in aid of performance. My lord, only one sentence. What they're doing is now, my lord, on the basis of this order, they're approaching, my lord, the ROC and wanting to change the, my lord, records. Now, my lord, this is affecting the business. And, well, secondly, my lord, they have also moved a receiver application asking for appointment of receiver over the garden, which is now coming up on the 21st of June. So we are, my lord, really concerned about that.
My lord.
My lord, before my learned friends ask, I'm the plaintiff, my lord, may I just reply to the point of law? My lord has rightly asked, my lord, whether prayer A of the plaint as well as the injunction application is maintainable. My lord, here, my lord, before even I refer to, I have two judgments in support of my contention. Before I refer to any judgments, my lord, first and foremost, I must point out that the entire records which were before the trial court, my lord, are not before, my lord. So I will satisfy, my lord, on the maintainability of my prayer, and thereafter, my lord, I'll seek an opportunity to file an affidavit to bring on record my plaint with annexures.
Very well,
all of
sir.
that.
Then do that.
My lord.
Don't have multiple hearings. If you want the trial court records to be brought
No,
here.
no,
No,
my lord,
you want to file an affidavit.
I'll file an affidavit, or if my lord directs, my lord, we can file informal paper books, whatever my lord is
Do that,
convenient
but
to my lord.
prima facie we are.
My lord, let me satisfy on that, because my lord, today if the order of stay on the award is vacated, my lord, because the order of stay that my learned senior friend is today seeking is vacating of the order, my lord. If my lord vacates the order, irreparable prejudice will be caused to my client as compared to the prejudice that would be caused, if at all, to the appellants before, my lord. The balance of convenience is in my favor. On the maintainability, on the legal point only, may I only submit first and thereafter cite two judgments. My lord, Section 34 of the Arbitration Act undoubtedly, my lord, allows a party to challenge an arbitral award. My lord, the crucial fact is Section 34 states that a party may challenge an arbitral award. Party is defined under the Arbitration Act. It says a party to the arbitration agreement. That arbitration agreement, admittedly, my learned senior friend will not be able to dispute, is not my client. I was never a party to the arbitration agreement pursuant to which the arbitration was commenced. I can show ex facie. I'm carrying a few documents which were there before the trial court. Ex facie, the settlement agreement that was entered into, on the basis of which the award was passed, well, that is vitiated by complete forgery, and that is a subject matter for pending criminal investigation. It is a nullity in the eye of law completely. This is not an, my lord will kindly bear in mind while deciding this matter, this is not an arbitral award on merits. This is a consent award arrived at pursuant to an agreement between the parties. If I can show ex facie that the agreement itself is vitiated by forgery, and that has been recognized by public authorities as well as the parties to that agreement, well, that agreement has to be stayed. Now, the difficulty arises that that agreement has been acted upon by the learned arbitrator and an award has been passed. Well, I, as a party, who good, bad, indifferent, well, I have put in money. I am claiming in the suit to have an interest in the firm. Well, whether that is maintainable or not, that is for the final adjudication in the suit itself. But I have established some prima facie evidence to show that I have some stake in the firm.
Sir,
If today
sir,
I'm sorry.
if you have put in money, recover that. Nobody stops you from doing that or stands in your way, nor will we. But in view of the bar in the clause of the whichever clause of the LLP, how could Vitrukas, without the consent of all the existing partners, transfer their share to you? Number one. Number two, that even assuming they did that wrongfully, that per se would not give you any right to participate in the business of the LLP. That is Section 42. Therefore, how can you assail the award? You recover your money.
Well, on the stake of my client in the firm, the agreement between the Mitrukas and Kajal Sarkar, Malad, that is the appellant before Malad, that has been categorically said to be forged and fabricated. It's a nullity in the eye of law. Malad will kindly envisage if there is a clause in the agreement.
Even assuming it is, what is your right?
I have entered into a fresh reconstituted LLP agreement. That is what governs the firm. That is my case in the plaint. My lord, let me place my paragraphs in the plaint itself. I have a reconstituted LLP agreement that was entered into. My lord, 15th May 2020, the agreement with Kajal Sarkar is a nullity in the eye of law. That is my case in the plaint. If that goes, my lord, the only consent that was required was that of the Mitrukas. I have transferred in my favor the share of the Mitrukas, leaving aside Kajal Sarkar because he was never a partner of the firm. It was an illegality and it was a nullity in the eye of law. Documents have been produced before the trial court to that effect. And an investigation is going on because of the forgery committed by the appellants before Muller. Muller, already 3 investigations are going on before various public authorities on the signatures forged by the appellants before Muller.
We'll do this. The parties shall maintain status quo, Mr. Shah. As of date, you file your affidavit.
Yes, yes.
File your
My lords, if I may mention just 2-3 facts to my lord's suggestions, basically.
Who are you, sir? The Mitrukas.
I'm for Mitrukas, sir.
Are
I just
you-
want to explain.
Are you opposing the respond numbers 1 and 2, or you're sailing in the same boat?
No, sir. I'm defending the respond. I am against the appellant number 1 and 2 for the
You're
very
against
basic
the
reason that I
appellate?
am also facing a.
Very well.
Yes,
Then,
sir. I have also filed FIRs
very
against
well.
the Kajal Sarkar for.
This is the
Yes,
problem
sir.
with the virtual hearing. This is the problem. Ishu. The appellants assail an order dated April 29, 2025, passed by the learned judge, commercial court, Shiliguri, whereby
No change of record matter.
the operation of an award, arbitral award, dated November 24, 2022, passed by Honorable Justice Ashok Kumar Ganguly, passed by learned sole arbitrator, has been stayed by way of an interim measure. Stop. Paragraph. The appellant number 1 is a limited liability partnership. Stop. The appellant number 2 claims to be a partner of the appellant number 1. Stop. The respondent numbers 1 and 2 are the plaintiffs in the suit wherein the interim order has been passed, being Commercial Suit 01 of 2023. Stop. The respondent numbers 3 to 5 are partners of the LLP. Limited liability partnership bracket in short LLP kore diyo. LLP. Stop. The paragraph. The appellants say that the LLP was constituted by an agreement dated November 11, 2019. Stop. The respondent numbers 3 to 5 or some of them, the respondent numbers Anita
3 and 4 only, sir.
Anita and
Only Sushil and Anita Mitrukar, sir.
3 and 4.
Respondent numbers 3 and 4 were the original partners. Stop. The paragraph. The partnership was reconstituted by execution of a subsequent agreement dated December 24, 2021.
No, Malad.
No.
31st January 2020, that's at page 226.
Page?
226.
Oh, 226.
This is where Kajol came in.
January 31, 2020. Stop. By way of such reconstitution, the appellant number 2 herein, Kajol Sarkar,
Yes.
came in as a partner of the LLP. Stop. Paragraph. It appears that subsequently, Kajol was expelled from the partnership by the Mitrukas. Stop. Kajol initiated an arbitral reference challenging such expulsion. Stop. There was also a reference between the assigner of the concerned tea garden and the LLP, wherein the grievance of the LLP was that in spite of assignment having been made, requisite documentation was not being completed in connection therewith. Stop. Paragraph. The arbitration that Kajol initiated culminated in a consent award. Stop. Kajol says that as a result, he remained a partner of the LLP. Stop. The other arbitration was also settled. Stop. Paragraph. The respondent numbers 1 and 2 herein, who are the plaintiffs in the suit, claim that there was really no settlement between Kajol and the Mitrukas. Stop. The learned arbitrator was induced to pass a consent award on the basis of forged documents. Stop. Therefore, comma, the arbitral award is a nullity, and accordingly the plaintiffs have challenged such award in the suit, since in the meantime the plaintiffs have acquired shares in the LLP. Stop. Paragraph. The learned trial court, upon considering the rival contentions of the parties, thought it fit to stay the operation of the arbitral award. Stop. We find from the order impugned that the matter has been made returnable by the learned judge on, it was May 8 was the date.
Yes, well, thereafter it was, well,
What is the date?
well, now it's 21st of June. Well, that is the receiver application.
Okay, well then the matter has been,
Receiver application.
as we see from the order ticket,
Appointment of receiver by petitioner.
the matter has been made returnable by the learned judge on June
21.
21, 2025,
21st.
to consider the plaintiff's essay for apostrophe prayer for appointment of receiver over the concerned tea garden. Paragraph. Mr. Shaha, learned senior counsel appearing for the plaintiffs, appellants, has drawn our attention to sections 23 and 42 of the Limited Liability Partnership Act, 2008. Stop. Section 23 basically says that the relationship between the partners inter se and the partners and the LLP would be governed by the agreement of partnership. Stop. The agreement is paramount. Stop. The clauses of the agreement bind the partners. Stop. Section 42 effectively says that a partner of a LLP, even if, says that even if an outsider acquires share in an LLP, that per se will not entitle him to participate in the business or management of the partnership. Is that substantially correct?
Yes.
Stop. Mr. Shaha says that even assuming for the sake of argument, says that firstly, which is that clause which says you cannot transfer without the
5C.
Clause 5 bracket is C, choto C, of the partnership deed dated,
Of the partnership deeds dated 11th November 2019 and 31st January 2020.
deeds dated November 11, 2019 and January 31, 2020. debars a partner from transferring his share to a third party without the consent of all the existing partners. Stop. Kajol never consented to transfer of the shares of the Mitrukas or any part thereof to or in favor of the respondent numbers 1 or 2 herein. Respondent number 1.
One here.
One.
It will be, since your lordship is talking about transfer,
My
that
lords, if may I point out the Kajal was
Please, firstly, you are not before
the
us here.
Kajal
Secondly, do
was.
not interrupt when somebody is dictating a judgment.
May I sincerely apologize for it.
clause 17, the
Yes,
clause
yes.
which restrains transfer is clause 17. And the clause which says no one will be inducted is clause 5C.
Oh, he will know.
Consented to transfer the receivers of the Mitrukas or the part thereof to or in favor of the respondent of one.
শোনো ওইটা যেটা ক্লজ 5C যেটা বলেছো না ওটাকে ক্লজ 17 করে দাও Stop. Further, comma, clause 5C এখানে 5C বলো of the said deeds of partnership provide that no new partner may be introduced without the consent of all existing partners. Stop. Mr. Shah says that therefore, comma, any purported transfer or assignment of the shares of the Mitrukas to or in favor of the respondent number 1 herein cannot have any effect. Paragraph. Learned advocate for the respondent numbers 1 and 2 oblique plaintiffs have strongly opposed the appellant's apostrophe prayer for stay of operation of the impugned order. Stop. The submission made by learned advocate has been briefly recorded herein above. Stop. Paragraph. We find that there are serious factual disputes in the matter. Stop. It will be only fair to provide an opportunity to the respondents to file an affidavit as they intend to do. Stop. Paragraph. Let affidavit in opposition to the stay petition be filed within, don't take much time, a week from date. Stop. Reply thereto, comma, if any, comma, be filed within
A week thereafter.
a week thereafter. Stop. The matter will be listed after 2 weeks. Paragraph. However, comma, since we propose to hear out the matter immediately after exchange of affidavits, and it is understood that the appeal will be heard out along with the stay application, comma, we direct that the parties shall maintain status quo as regards the tea garden in question, as also the partnership firm in question, till further order.
Yes. Yeah, it takes care of it. Very grateful.
My lords.
The receiver application naturally then cannot be heard on the 21st because your lordship
You cannot appoint a receiver in view of this order.
That is understood.
We will observe in paragraph. I had a paragraph. In view of this order, comma, the learned trial court is directed to adjourn the application for appointment of receiver till the disposal of this appeal.
grateful.
এই একটা আনিয়ে রাখবেন আমাদের 2 কপি এটা এই বইটা লাইব্রেরি থেকে আনিয়ে রাখবেন
Item number 3.
Number 3, pursuant to Lordship's given.
My lord, I appear for the appellant. My lord.
Why are you on the virtual platform?
My lord, I'm so sorry, my lord. I'm not in Kolkata. My lord.
Not in Kolkata.
My lord, would kindly extend my lord's benevolence to permit me to appear for my virtually, my lord.
Yesterday, I have affirmed due to his health ground. And I have given a copy to her.
Oh, you are for the respondent?
Yes.
Yes, so accept, you file your reply if you, do you want to file?
Yes, my lord.
2 weeks, my lord, 2 weeks, my lord.
2 weeks.
We are filing our affidavit.
2 weeks. Affidavit in opposition filed on behalf of the respondent be kept with the records. Paragraph. The appellant will be at liberty to file affidavit in reply within 2 weeks from date. Kore date ta diye dao.
The interim order expires on 30th of June, my lord.
Paragraph. List the matter after 2 weeks. Date ta diye diyo ota abar.
The interim order expires.
The interim order that is in subsistence shall continue till the end of July, 2025, or until further order, whichever is earlier.
Deeply obliged, my lord.
So grateful, my lord, so grateful.
Item number 4.
Please, your lordship, I appear for the appellant, my lord.
For the respondents.
10th of
June.
June, your lordship had given me one last opportunity to.
Oh, yes.
But, 2 things I'll submit. The time to deposit the money balance, security money was till yesterday. The client had sent the money to my advocate record late last evening. Your lordship takes it up at 2 o'clock. My advocate record is in the process of depositing the money, my lord.
Come at 2. But Mr. Gupta, if at 2 we find still it has not been deposited, then Kochang Fu.
I hope the money will be deposited by the.
Much obliged.
Item 5. Item.
You are arch infra.
I'm arch infra, my lord.
Very well.
But we are not arch rivals, me and Mr. Chaudhary.
Against what have you come up?
An order, my lord, of grant of temporary injunction ex parte. Temporary injunction ex parte, despite allowing us to participate in the proceeding, taking on record notes on arguments in connection with the injunction application, yet not permitting us to file a written objection because we had appeared belatedly. Then, my lord, it's the procedure against which basically I am aggrieved. Now, my lord, we got notice, we applied, we came slightly late. We were not in a position to file a written objection within time. But on the day we appeared, or immediately thereafter, we filed 2 applications of demurrer. One seeking for withdrawal of the leave that has been granted under 12A of the Commercial Courts Act. And the other for the purpose of rejection of plaint on a particular ground.
Mr. Banerjee, almost as a matter of course, if it's an ex parte order which is assailed before us.
No, this is a temporary injunction.
Yes.
Temporary injunction application at the contested stage, but granted virtually ex parte because our contentions were not taken into consideration. We were allowed to participate.
On the day the order was passed, did you appear or not?
Yes, we were there.
You were there.
We were there. We put in our written arguments also. The learned court below said that we'll permit you to put in your written arguments. You cover whatever you have to say in your written arguments. We did that. 2 demurrer applications, one on a demurrer to the plaint, the other on a demurrer to the application for temporary injunction were filed by us. First one being a moment, the second one being consequential. The learned court said that it would not hear out the demurrer applications before the injunction application and fix the demurrer applications for hearing subsequently. In the meantime, the court said that we should participate in the hearing of the injunction application. We said we wanted to file a written objection. Court said that because we had not filed a written objection by now, We will not be permitted to file written objection, but to participate in it, make our submissions and to file our notes. We participated in it, we made our submissions, we filed our notes. And when the order was passed, it's an order recording that the temporary injunction application stands disposed of on contest. However, our notes were not taken into consideration because of the fact that we had not filed any written objection.
Was there a direction for filing, or was leave granted earlier to file written objection?
Yes, my lord, leave had been granted earlier.
So therefore you can't complain because you chose not to file.
My lord, we went there and we applied, my lord, for filing of a written objection also. It's not that, my lord, we didn't apply, but yes, there was nothing peremptory in that direction to suggest that our non-filing would debar us from filing the written objection altogether. The only prayer I was seeking is this: there is an injunction which restrains me from dealing with any of the flats of a particular complex which has been developed. He's a supplier of goods. He says that monies are due and payable to him.
What is your claim, Mr. Chaudhary?
His is 3 crores, mine is 9 crores by way of counterclaim, which I have already filed. That counterclaim has been taken on.
That's all right.
No, that's been directed to be taken on record yesterday in a civil divisional application because.
How many flats are there? How many flats have been injuncted?
About 9.
Kindly see,
More than 180 flats, I am told everything has been restrained for a claim of 3 crores. Each of the flats will be around 1.5 to 1.7.
Not go into so much of detail.
Yes.
That I don't want to contradict my learned friend. Kindly see my lord's order of 16th of May.
In this matter?
Yes,
Yes, it had come up once.
Oh,
that I had suggested mediation. I had suggested take away all your flats, secure the claim by a bank guarantee. It's an admitted claim. My learned friend said he would take instructions. That's my lord, paragraph 5.
oh yes.
Yes, Lord, we had, I have gone back to my client on this.
Yes.
And my instructions are that, Lord, as far as mediation is concerned, nothing fruitful might emerge because there were attempts on the part of the client to sit for a mediation.
What
earlier.
about securing by way of bank guarantee or otherwise?
There I'll tell you, Lordship, what is the case. He has made out a claim on me. The claim on me that he has made is contradicted by me in the written statement, which is there on record, yet to be taken on record. I also have a counterclaim against him. Under such circumstances, an blanket injunction has been made in this manner over all the flats. If today, my lord, I secure the amount, then this becomes an attachment before judgment. It gets a higher relief in respect of an interim application which did not make out a case for attachment before judgment at all. First of all, his claim, my lord, was claim is monetary in nature, it will not be irreparable. And this and other facts are there which are germane on record. Our written objection, if it was there in the court below, it would have been considered appropriate orders passed. However, today, my lord, he comes up with a blanket, or he's benefited by a blanket order, which we say is unlawful. In toning down that blanket order, if we secure any money today, then he gets advantage of an order of attachment before judgment when he has not made out that case.
Let us see the order. Today, this principle of law that you are saying, Mr. Banerjee, has been watered down quite a lot. Starting from Lister and Stubbs, 1890-45 Chancery Division, page 1. And then AIR 51 Calcutta, D.N. Sinha, Justice D.N. Sinha. All those 11, 12 grounds. It's been watered down. Today,
now it has become pragmatic. Now it has become more pragmatic.
Prima facie, he has a money claim which is not a bogus claim, which does not appear to be a bogus claim. We are more inclined to grant some kind of security. So we start with
I'm only
a mindset.
I'm only humbly praying this.
Yes.
My lord, had we an equal opportunity of participating substantially in substance before the temporary injunction before the court,
then we will relegate it. We'll send it back.
Kindly relegate it, Lord, and send it back.
Send it back, and with a time frame.
Yes,
with a time frame, but 1 second, Mr. Chaudhary. But till it is reheard, the order will not be vacated. The order will remain.
I have succeeded once.
And of course, the order will abide by the hearing which will be made on contest.
Yes.
Actually. That I'm
Chaudhary, there we are again trying not to go to the merits of the case.
Lord, but I must point out 3 things. Number 1, my lord, 29th of August 2022 is the ad interim order, which has continued. My learned friend has chosen not to file an affidavit in 3 years. He's filed an application for dismissal of my injunction application, and he insisted that that application should be heard before the injunction application. His arguments are noted, his cases are, my lord, considered. Now, my lord, upon full adjudication, this order has been passed. It, my lord, can't be today said it's really an ex parte order without considering his version. He's filed a written statement. Most importantly, what is also not told to your lordship is that the initial order of 2022 was in respect of a certain number of flats, 8 flats. There was an error in the impugned order because it did not limit the injunction to 8 flats. We immediately filed an application before the learned court below, requesting the court to correct the order and limit it to 8 flats. So, my lord, you can't come and say it's an outlandish order. And, my lord, I just want to draw your lordship's attention. If your lordship takes, my lord, the impugned order from page 6.
Where is the correction?
I'm sorry.
Correction?
No, that's not happened.
Not happened.
I have applied that it should be corrected. I am not entitled to more than 8.
I'm sorry, my lord, this is the application which is filed.
Therefore, let us do that. We can do that also.
And let it go back. And let it go back. I mean, if your lordship keeps the injunction, I'm humbly saying this, in whichever form my lords deem fit and proper, kindly retain the injunction, kindly give me an opportunity to contest it out there and say that it would abide by the result of my contest. I'll tell you, lordship, what happened.
Have you filed the written objection or not?
I wanted to file the written objection. I was debarred from filing it. I had filed, my lord. Now, this 3-year thing which Mr. Chaudhary has been said, he has not been properly instructed. There was an arbitration clause, as a result of which the suit was taken off file. Subsequently, the matter travelled to this honourable court, whereupon that was set aside. Suit was restored. Thereafter, my lord, the written objection stage came.
See, Mr. Chaudhary, the only thing is the learned judge refers to the verbal objections of the. So
if somebody doesn't file, what would the
we
court
know,
do?
We
Now,
know.
my lord, please give me 2 minutes.
Yes.
My lord, please take, my lord, page 5 of the impugned order. Because what he's asking for is setting aside, rehearing, as if, my lord, the learned judge had committed an error. And, my lord, 3 years the learned judge gave him time. If somebody doesn't file for 3 years, my lord, please see the date of the injunction application and the, my lord, please see, my lord, page 5 at the bottom.
Yes.
My lord, defendant orally submits. Then, next page, my lord, has orally, last sentence on page 5, defendant has orally sought to raise the following objections and submissions in opposition to the injunction application and has filed a notes of argument about the same. At the outset, the defendant submits present suit has been filed without 12A compliance. Then, my lord, vague statements. Then he's filed an application for revocation of leave. Then additionally, on 11th February 2025, the defendant filed an application seeking dismissal of the injunction application on several grounds. Defendant submits that this application, being a demurrer, ought to have been heard before proceeding with the injunction application. However, the learned court has closed the hearing of the injunction application and reserved orders thereon, while leaving the defendant's application for summary dismissal pending. Defendant submits that the demurrer should be heard first, injunction should not be disposed of. Further submits that it is in prejudice by the failure of the court to hear the demurrer application, as the defendant reasonably expected that the demurrer application would be considered before any objections on the merits of the injunction application. This procedural disadvantage amounts to a violation of the principles of natural justice, potentially leading to a miscarriage of justice. Therefore, the defendant requests that this court allows an opportunity to file written objection on the merits of the injunction application till the disposal of the demurrer application. Defendant further submits ad interim order, etc. Then money claim, no prima facie case as made out in the plaint. Then he's argued. Now, my lord, please note the date of, my lord, the filing of the demurrer application. That's, my lord, 2025. My lord, order number 7 on 16 December 2022 is where he is directed to file written objection against the injunction application as well as written statement. He files a written statement. doesn't file, my lord, anything from 2022 to January 2025. In January 2025, he could have filed a written objection. He didn't. He filed a demurrer and said, hear my demurrer, please don't hear the injunction application, otherwise there is failure of justice. This is not, my lord, reasonable or correct conduct. This does not, my lord, in my humble submission, entitle him a right, my lord, to now come, have the order set aside, file a written objection. He could have argued on merits. I'll, my lord, show, my lord, that from the material there is nothing to suggest that the order is wrong. My lord, kindly, my lord, this is, my lord, I understand what your lordship said. Parties should be heard. But will my lord, there must be penalty somewhere. 3 years you don't file. Even then you file demurrer. Then you say, I won't let you go into merits of the injunction. First hear my demurrer.
1 lakh cost. Take it. Body will modify the injunction, restrict it to the 8 flats,
Yes.
send it back for fresh hearing. Upon filing of written objection, subject to payment of the cost that we just now indicated.
Lord, may I, on
why
the
don't
cost,
we-
Lord, I will not,
If-
on the cost, Lord, I will not make any
My lord,
submission.
why don't we go to mediation?
No, my lord, we will not.
We are not
It will
willing.
fail. It will fail.
We
We
no,
make an
no,
approach.
this attitude of your client is not appreciated by us.
Lord, I
May
had
I
brought up-
just say this?
But
I,
we can't force your client also.
my lord, may I just say this?
Yes.
I constructed for you. You're a developer, I'm a sub-developer or a contractor. I constructed for you. You, at my cost, you are selling the flats to third parties.
I had to procure
I have
materials
a-
from outside
you
in
may
order to
have
buffer
claims.
my
You
construction.
may have claims.
have
I have
claims.
claims.
You
let's
you
be-
you ran away midway. You
Let's
came
be
back later.
reasonable.
My lord, another thing, Lord, which Lord, perhaps we need to point
Let's
out to your
work it
lordship
out
is
and
that
finish the matter.
this 5 years, which is being sought to be say 3 years, 4 years, the matter has been kept, my lord, pending there before the court below, is perhaps not correct. My learned friend may not have been properly instructed. After we had entered, my lord, there was an arbitration clause, as a result of which the suit was taken off file and sent to arbitration. Against that, my learned friend was aggrieved, came up before this honorable court in revision. The revisional application was heard out on contest. Subsequently, the revisional application was allowed and the suit was put back on file. From there, an SLP was preferred, the SLP was dismissed. Therefore, this after that we came there, our demurrers were already there. We said, let us file a written objection. Now, my lord, insofar as my client is concerned, my lord, this entire period of 3 years was not a period in which he sought adjournment after the other. The suit was off file for close to around 2 years.
Lord,
18th October 2023, the
my
suit
lack
was
of confidence.
Section 8, the suit was dismissed.
is
That's
not-
neither here nor there, but then it covers a period, my lord, I am saying.
But you are sure that your client will not even try mediation.
My lord, I had advised him to go and try all possible alternative dispute resolution methods available, because they are always more advisable than going into a contested hearing of matter, particularly here, my lord, where it takes time, my lord, in our courts below.
Lord,
But, my lord,
my
I
learned
was
friend-
told,
my learned
I was
friend is
told
not
thrice
correct.
he had sent his emissaries, and they have been threatened. They have been threatened even with the threat of being roughed up
By whom?
by their persons, saying that they are not going to sit.
These allegations,
Now, my lord, I didn't want to make them. I don't want to make them either.
Mr. Chaudhary, even as of now, says his client is interested in
settle it.
mediation.
You ask him
My
to
learned friend, my
sit together.
instructing advocate is here. I have told him ad nauseum that this should be
Your
the way forward.
instructing advocate may not be advising his client properly. I'm sorry.
You take charge.
Mr.
I'll bring the
Banerjee,
client
you
to
should
you.
speak with the
ওরে settle করে নাও না, কি আছে, কম বেশি করে। Milord, what I find, Milord, in
Lord,
these-
alternative wisdom has dawned on him. He says that he'll be ready to have a sitting.
Yes.
If he's ready to have a sitting and it's a happy golden handshake, then I'll be the happiest.
Milord, what I find, Milord, is if you settle now, Milord, both parties benefit. When you
He's
see
saying
interest
so.
cost will
He's saying
burden
so.
both of us. Let's
He's saying
do it.
so.
I'll bring my client. We'll sit together.
Sit-
and sit together.
Sit tomorrow.
Yes.
I am not that trained mediator.
No,
With
no,
the
we are not
full-
referring it to the mediation committee.
Please adjourn it for a week and
Yes.
do tomorrow.
I'm
Okay.
sure Mr. Chaudhary is trained enough
I
to
have
not
never,
make the party see reason. I am a bit of a
We'll try together.
I'm a failure at ADR.
After we heard learned advocates for the parties for quite some time, learned advocates, learned senior advocates, now level case debe amake. Parties for quite some time, learned advocates on instruction say that an effort could be made between the parties to settle the dispute out of court. Stop. We appreciate such suggestion. Paragraph lists the matter once again. A week hence, data diye dao. Stop. We hope that on that date, learned counsel for the parties shall be in a position to tell us that their clients have settled the matter out of court.
Kindly give us a week more. That provides for an opportunity of resitting twice or thrice to finish it off.
2
Right?
weeks
2
hence,
weeks.
data diye dao.
তুমি বলো না আই এম রেডি আমার কোনো চাপ নেই তুমি করে নাও আমার কোনো অসুবিধা নেই Mr. Chaudhary is great at mediation. I am very poor at mediation. So it will be Mr. Chaudhary, Mr. Mukherjee. I'll be there to assist.
Aren't you a trained mediator?
No, my lord. I have
Are you?
No.
No.
But he's Milord natural.
Natural.
He's natural.
So 2 weeks hence, we are keeping it on the 31st of June.
31st of June. We'll amend the calendar accordingly.
Dakho. Ore baba.
Item 6.
Cheater.
But,
Yes, yes. Your suit for cancellation dismissed.
Yes.
Mr. Surajit Nath Mitra is waiting there.
but
He's trying to hide.
Paper books filed.
yes,
Straight away to the impugned order.
Milord,
No.
just outlining the 4 compartments of Milord the appeal, and then Milord straight away Milord to those 3 orders. Number 1 is rejection of application for leave to disclose documents filed by the plaintiff under Order 11, Rule 5. This is by the order dated 3rd of October 2024.
Rejection of plaintiff's application
Yes.
for disclosure of additional documents.
Yes.
And this is under order?
Order 11, Rule 5, as amended by the Commercial Courts Act.
Order dated?
Milord, 3rd of October 2024.
Yes.
Second, Milord, is order directing redaction of evidence.
Order directing?
Milord, redaction of evidence, Milord, under Order 19, Rule 5. By the order dated 18th of January 2025.
Can we come back in 3 minutes?
Yes, yes, Milord, I am here, Milord.
My lord, only thing is, my lord, I understand the paper books which they have prepared do not contain all the papers.
Where they go?
We have
We made a
prepared
mistake.
that.
Supplementary.
Yes, we
yes,
have
no, no
prepared, my lord. May I
Very
give
well,
it to
fine.
them and may I file it?
Yes, yes.
Yes, yes.
Fine. We'll come back.
We have no objection.
Let it-
The second chapter, my lord, is redaction of evidence, leading, my lord, to the order dated 18 January 2025. The third, my lord, is closing of evidence by an order dated 22nd January 2025. And the fourth, my lord, is the decree itself. Now, my lord, these are the four compartments of the matter. The date of the decree, my lord, is 28th January 2025.
22nd January, evidence closed,
Yes.
and 28th January.
That part of, I'll just indicate, my lord, that's one of the major issues which we will urge before your lordships.
Yes.
18 January, Lord Alja, I'm going to show all these documents later, my lord, in greater detail. 18 January, my lord, redaction was directed. 21st January, adjournment, my lord, was refused. 21st January, oh, I'm sorry, 21st January, we had an order, my lord.
Haven't you prepared a short list of dates?
Yes, yes. No.
We are not rushing you at all, only to assess roughly how long you'll take.
It'll take a little bit of time.
Yes, yes, no problem. This half?
Yes, easily, my lord.
Easily this half.
Easily. The questions, my lord, were on to whether, my lord, he's not happy with me. 2 days, my lord, I've been missing in action.
He doesn't have 5 minutes of time because it's not one.
কি হচ্ছে দৈব বাণী হচ্ছে আকাশ থেকে দেখো তো কি হচ্ছে
Oh my God. This is Mr. Aniruddha Chatterjee. May I request
In
your
this
lordship
matter?
to, yes, yes. Kindly, my lord, would your lordship permit him to be logged off?
Well, he doesn't have the right to even pay for that.
Wherever he is. No, this is a lucky day for me, my lord, because he is not here.
Where is he?
I'm in Port Blair, my lord. I'll be there in some time.
Port Blair is the circuit now? Yes, yes, yes. Yes. This half, this half.
My lord, 18 January, the order comes, my lord, for redaction. Before that, my lord, the sequence is,
Yes, 1 second. Just refresh my memory.
Lord, kindly see it from the Commercial Codes Act. Those, my lord, have the amendments to the. Oh, this is would also be.
Yes, this would also have.
Yes, but
Order 19.
Order 19, Rule 5. A court may, in its discretion, yes, Lord, some of the books, my lord, don't have the amendments brought in by the Commercial Codes Act.
Yes.
Down. No problem.
Yes.
May I please it, Lord? A
Yes.
court may, in its discretion, for reasons to be recorded in writing, redact or order the redaction of such portions of the affidavit of examination in chief as do not, in its view, constitute evidence. So no, not evidence at all. Then second is return or reject an affidavit of examination in chief as not constituting admissible evidence. So, redaction is even more serious. If it's evidence, even if it's not admissible, it can't be redacted. Now, redaction comes. This is immediately after the order rejecting my documents.
Hmm.
This is 18th of January. We immediately, come to court. From the previous order, we had already come.
Revision.
From all these orders, there were revisions. So, in the first matter, the lack of permission to disclose documents. In that matter, this honorable court clearly gave me liberty to pray. The petitioner shall be at liberty to pray for an adjournment before the learned trial court if occasion so arises. With this order, I thought that it would not be a difficulty in any way, to ensure that the matter could be heard out by the High Court. However, I was wrong, and I was even at this stage, we were not pressing for an order of stay, because in a matter where there is an order for expeditious disposal or a request by the Supreme Court to the High Court to dispose of a matter, it is not right, to file an Article 227 application and try and get an order of stay, because that, unless it's very serious, because that would, go against the spirit of the Supreme Court order. So unless it's, unless heavens are falling, I at least would not ask for an order of stay. So I did not ask for a stay. I said, please allow the matter to be adjourned. So that request was accepted, and the court said yes. Now, on 21st itself, there was oral communication to the court below that such an order, has been granted. So please adjourn. Instead, the court gives me a show cause. Why aren't you proceeding? On the next day, 22nd January, we file an application before the court below, requesting for an adjournment. Court, fixes the matter the same day, 22nd at 1:30 for further consideration. Huh? And right to adduce evidence is closed. Then, this is a government entity. There's a process for filing and having applications approved. So, we took another 4 days or 3 days, to file the second Article 227 application challenging this redaction, etc. That was filed, and that was taken up for consideration after mentioning on 27th of January.
1 second.
I believe, between the 22nd and the 27th, there would be, a weekend, and there would also be 26th of January. So
23rd.
23rd. So, we had very little time. We filed, mentioned before the learned judge. Listing is very difficult, but we managed to get a listing on the 27th, considering the urgency. 27th of January, the learned judge was taking up both matters and was going to,
Both matters.
Earlier 227.
Oh, I mean the High Court.
Yes, liberty for adjournment, this, etc. This came, I'm sorry, this 27th it was filed, and 28th, we had it, both matters. The earlier matter was fixed at 1:15. The other matter, would come up in the list of urgent matters from 2. Now, my lord, we went. The learned judge, my lord, expressed an opinion that you can't race ahead. I have to consider both. I'm considering, I'm hearing, but I'm going to stay because otherwise the decree will, my lord, render it all infructuous. My lord, there was a disagreement, my lord, with my learned friends, and the learned judge released the matter in the afternoon at 1:50. Second release, I again went back at 2 o'clock, said, please, at least it will be infructuous. Please don't do it. The learned judge said, I'm sorry. I've released one, I'm releasing the other. 2:30. We wrote a letter to the Honorable Chief Justice requesting for an immediate assignment so that we could go and request for a stay because we knew that it will be over. Unfortunately, it was at 3:30. So the secretary said I could have done it, but then it's already 3:30. And same evening, the judgment was uploaded. Delivered, heard, delivered, judgment uploaded. So, my lord, we lost the race, but then it's not the final race. We're before your lordships today. The judgment, the decree, my lord, doesn't, when I place the decree, it will be my endeavor to show your lordships that it doesn't take into consideration any relevant fact. And, my lord, it is replete, my lord, with error, for which it should be set aside. Secondly, my lord, principle of committee of courts, judgments upheld up to Supreme Court on the same issue. It's a public matter. So, my lord, I'm not saying public matter to prejudice your lordships. I'm saying it because all matters are my lord, evidence relating to public issues under Section 44 of the Evidence Act, my lord, would be admissible. I'll address your lordship on those issues. But first, my lord, to go back to the root of the problem, the order, my lord, refusing disclosure of documents.
3rd October.
3rd October.
Where shall we find
My
it?
lord, the suit, my lord, was filed in, there is some, my lord, delay. It was a new act, my lord, with new timelines. We were also, my lord, not fully conversant with what is to happen or the repercussions which would follow. I confess, my lord, that there is some lacuna, some
New Act money, Commercial
Courts Act. The suit was filed on 27th of October 2014. Then, my lord, this was there were similar two suits were filed in respect of allotments where, my lord, deeds of conveyances had been issued. Now, subsequently, my lord, there was
so on the date that this division bench passed that order in the other matter, their suit was pending. Suit was pending.
Look, really speaking, if your lordship looks, there are three, my lord, timelines in the matter. The first timeline, when nobody did anything, was when the matter was before the learned single judge and before the division bench and then before the Supreme Court on the main matter, because we always knew that that would effectively decide much. Now, so this is number one. Second is a large length of time when, my lord, Order 7, Rule 11 was pending from trial court to Supreme Court through this court. So nobody did anything. Now, when Supreme Court dismissed his special leave petition from rejection being upheld by the High Court of his Order 7, Rule 11, within 4 days, our application was ready. Within 4 days, we moved before the learned trial court for leave to disclose further documents. So that, my lord, I would say, my lord, is my saving grace. May I just give your lordship a few dates? 27th October 14, my lord, is the filing of the suit. In 2015, the learned single judge decided all those writ petitions. Now, this is a suit which was filed before the civil court at Barashat. On 12th of July 2019, order was passed by the Barashat court, my lord, directing transfer of the suit to the commercial court.
Yes.
At that juncture, my lord, we didn't challenge the order, but Now with all these judgments, my lord, Ambalal and all these cases which have been since decided, we now feel, my lord, and it's possibly correct that this would not be
a commercial cause.
commercial cause. But however, we've accepted the order. I'll also address on that whether decree would ultimately.
If it is not a commercial cause, then what's
Whole
the
thing is
fate of
void.
the decree? Yes.
Whole thing is void. I'll come to that. This is an allotment of a plot of land.
Residential,
No, this is commercial.
commercial.
But this is an allotment of a plot of land in a tender process, which has resulted in a conveyance. It has to be land being used for commercial purpose. This is land which was used for grazing. By no stretch of imagination can anyone say that grazing is for commercial purpose. So now if you read that, my lord, with Ambalal, whatever be the nature of the contract, it will never be, my lord, a commercial contract. The concerned date is the date when the use of land as at the date when the agreement was entered into. On that date, pure, my lord, fallow land. So, my lord, all of it is, my lord, of no effect. My lord, I'll address your lordship on that. However, my lord, 12th of July 2019 is the order of transfer. From 2019, my lord, matter remained pending. 19th July 2021, Order 7, Rule 11 was rejected. My lord, kindly, my lord, see page 590. This is in volume 4.
No, 19 July it was filed. 7 June it was rejected.
I'm sorry, my lord, my mistake, my lord. 19th July filed, 7th June rejected. 7th June is at 590. Volume 4, page 590. Limitation, delay in, my lord, serving writ of summons, lack of cause of action, because our case was that we've discovered fraud recently. All of that was, my lord, argued, ultimately leads to rejection at page 596. The application for rejection of plaint under Order 7, Rule 11, read with Section 151, stands rejected on contest without costs.
Yes.
Now, this is, my lord, on the 7th of June, same year, my lord, 3rd of November 2022, the division bench, my lord, decides the writ petition appeals. Same division bench, my lord. Your lordship's judgment is at page 226. It's an important date. Both, my lord, the learned single judge deciding the writ petition and the division bench, my lord, were cognizant of the filing of the suit because it's reflected in both judgments. Subsequently, my lord, after this is 3rd November 22, few days later, my lord, on 6th of December 2022, we file a statement of truth under Order 11, Rule 3 of the Code of Civil Procedure. But this is an important event because my learned friends say that having filed a statement of truth saying that all documents in possession and control relating to the matter have been disclosed, you were not entitled to come and try to disclose further documents. So, Lord, I'll bring that to your Lordship's notice. Then, my Lord, this is 6th of December 22. 7th December 22, Lord, page 707 in volume 5 is, my Lord, I'm sorry, my Lord, the page number is a mistake. The page number is of the statement of truth. On 7th December 2022, the matter was adjourned.
That is not reflected in your list of dates.
That is not there in the list of dates, my Lord. My friends, my Lord, have filed this supplementary paper book. My Lord, at page 40, I brought the order separately, but I'm grateful to my learned friends for filing this. A third paragraph from the top, my Lord. As per verbal submission of learned counsel appearing on behalf of the defendant, as well as considering pending revisional application before the Honorable High Court, Calcutta, let the next date be fixed after few long days. So, my Lord, defendant is my learned friend. His order 7, rule 11 has been rejected. He's filed an article 227 application and he wants the matter again after a few long days. And, my Lord, December matters fixed almost 2 months later, 21st of February. Now, my Lord, before that, on 23rd of January 2023 is an important order. My Lord, page 637 in volume 5. Six 637, volume 5. This is a
Balaji had gone up against the DB order.
Yes.
Acha.
And in that, my Lord, they went to Supreme Court and said that they had succeeded before the division bench. And, my Lord, please, my Lord, see page 638. We thus dispose of the special leave petitions with the aforesaid clarification as that suit will be determined on merits, deholds any observation made against the petitioner, even though the judgments are in favor of the petitioner. So, Lord, when this order comes, it now becomes necessary for me, and I need to do this by abundant caution. I must, to show, my Lord, what had happened with regard to the process, I now want to disclose all the documents in the other matter, other cases of allotment. Though, my Lord, under the Evidence Act, it is possible for me to argue that the contents of a judgment are admissible evidence because it is a matter relating to a public right. However, I don't want to take a chance. I would now have to disclose other documents relating to other allotments to prove that the whole process was wrong. Till now, I would proceed on the fact that the same allotments, the same process was taken up for consideration and was found to be unlawful, and cancellation of allotments were upheld by the Honorable Court. single bench, division bench, Supreme Court. So, my lord, the suit would be very easy for me because he was a party there. I would just say that this has been cancelled. So, therefore, only question which would arise in the suit is where if the process is wrong, if the allotment is wrong, just because I have executed a conveyance, would you survive? Or am I entitled to have the conveyance, my lord, delivered up and cancelled? But with this order, I have to now argue afresh. I may have to argue afresh because the only saving grace is that this is a matter pertaining to a public right. Allotment was a public right. So therefore, it is admissible evidence, but I don't want to rely on a fine point of law. I wanted to disclose documents. This, my lord, is a very important order. And this is, my lord, 23rd of January 23. Now, when this order comes, we are not proceeding in the commercial court with the suit because his rejection of Order 7, Rule 11 is being argued before the High Court on a regular basis. That also ends, my lord. This is 23rd January 23. On 22nd March 24, that ends. The division, my lord, the High Court rejects his challenge. Judgment, my lord, at page 597. Volume 4 again. The other side की list of dates नहीं है जाओ एक खुद नहीं
Very well. Do we need to see it?
No.
Darkar nahi. Yes.
Huh? Then, my lord, this is 22nd March 24. Even then, my lord, nothing happens before the commercial court. Neither plaintiff proceeds nor defendant objects. Defendant also wanted an adjournment because he is now in Supreme Court again. Supreme Court rejects his special leave petition at, my lord, page 634.
Supreme Court against rejection of 227.
227. 6th of May 2024, page 634. I'll read the order, my lord. We find no reason to interfere with the impugned order.
Yes.
We find no reason to interfere with the impugned order, especially as the special leave petition has been filed challenging the impugned order by which the decision of the trial court was confirmed in declining to exercise power under Order 7 to 11 CPC. Though we are not inclined to interfere with the ultimate conclusion by the High Court in confirming the order passed by the trial court, we make it clear that the observations made will have no bearing on the further proceedings in the suit. Needless to state that the trial court shall take into consideration the order passed by this court in SLP number such and such, dated 23rd January 23, while disposing of the suit, which is that order, that nothing will be binding. Then, Mr. Such and such learned senior counsel appearing for the petitioner submits that the suit is pending since the year 2014 on the file of the commercial court, which is not correct. Thus, we direct the said court to make an endeavor to dispose of the suit within a period of 9 months from today. Now, my lord, I say this, that whatever time was taken before this date by either of the parties, past conduct, etc., is no longer, my lord, relevant. My lord, you go up to the Apex Court cognizant of everything says 9 months. I'm not punished any further by Apex Court. Nobody is punished. You're not punished. I'm not punished. Expeditious disposal is not punishment. You can't now dig out those earlier years for right reasons or wrong reasons and, my lord, castigate me. My lord, this order, my lord, is page 634. 6th of May 2024. 11th May 2024, my lord, we filed an application under Order 11, Rule 5. Within, my lord, 5 days.
Yes.
On 13th May 24, 2 days thereafter, volume 6, my lord, page 843, the Learned Commercial Court issues a show cause to me. My lord, please see, my lord, 843. May 2024.
Yes.
Learned advocate for the plaintiff appears and files Hajira along with an application under Order 11, Rule 5, read with Section 151 of CPC, praying for seeking leave to disclose additional documents on the grounds stated therein, copy served. Learned advocate for the defendant appears and files Hajira with fresh Wakalatnama. Learned advocate for the defendant also files an application under Order 11, Rule 14, read with Section 151 of CPC, praying for the passing an order giving directions upon plaintiff to disclose, furnish, produce minutes of the meeting of the Board of Directors of the plaintiff from 99 to 24. So he wants me to disclose these documents. But my lord, this application was never heard. My lord, we had indicated to the learned court, my lord, that he also wants me to disclose half the documents, or my lord, some of the documents which I want to disclose. Matter ignored. This application left pending. Then heard both sides, perused application as well as case records, from where it transpires that today is fixed for PH. Plaintiff did not file evidence in chief since 23 and has filed the application at the stage of PH. Plaintiff had remained silent from 22 till 23 in filing the same application at the stage of case management hearing. There's been no case management hearing, which my lord learned judge admits later in one of the orders. Considering the aforesaid facts and circumstances, I am of the view that the plaintiff is unnecessarily dragging the suit which is still pending since 4th September 2020 after being transferred to this court for disposal. Hence, application under Order 11, Rule 5, read with Section 151, is rejected, being infructuous. And the plaintiff is to file show cause as to why the suit shall not be dismissed for default. So first day my application is rejected. The learned judge, my lord, if I may humbly submit, in May 2024 had perhaps already decided that I would not be given a chance, my lord, to file additional documents and explain the process. We, my lord, immediately come to the High Court during vacation because things were getting serious. 28th of May 24 at page 844. So, my lord, this order was, this rejection of my application was set aside and I was permitted to file a reply to the show cause, costs per my lord waived. And I again went back. This time, my lord, for hearing of the application. So, my lord, please see 6th May 24, Supreme Court says 9 months after looking at everything. Learned judge, my lord, within 3 days, without even considering Order 11, dismisses it. And now when I go back, after, my lord, 28th May 24, consideration goes on, my lord, till October 24.
Yes.
Here, my lord, my argument is that from May till August, the learned judge did not dispose of the show cause as to whether my suit should be dismissed or not. 14th August, that is disposed of. I am allowed to, my lord, contest the suit. Hearing continues. 3rd October 2024, my application is rejected. Principal argument was this, my lord. Right to disclose documents in a transferred suit is a vested right. Now, this right has to be, my lord, specifically closed. Now, after this suit was transferred, there was a direction that there should be case management hearing. There was no case management hearing. There was no peremptory direction. Yes, there was a direction. I, my lord, went and filed a list of documents which were, my lord, relied upon. But this is really a vested right. Sum and substance, in a suit, my lord, which is filed as a commercial suit, and in a suit which is filed in the civil court, there is, my lord, a difference. The Commercial Courts Act makes a difference. In a suit filed before the commercial court, I have to, my lord, disclose all documents pertaining to the transaction in my possession and control, and I have to state everything. While, my lord, in a civil court, it's, my lord, much more restricted. The old rules of pleadings apply. Plead, don't plead law, don't plead evidence. But in
now evidence has to be annexed, no? The
Yes.
documents you rely upon.
in a commercial suit,
In the ordinary suit?
no, it's not so strict, my lord. It's not so strict.
CPC, after the amendment of the CPC?
Yes, I have to disclose
The documents you rely upon
Yes,
will have to be disclosed with the plaint.
yes. But I, my lord, need not disclose documents that I do not wish to rely upon. While in a commercial suit, I have to do that also. My lord, this is, my lord, I heard this once. I'm told it's, my lord, called the Red Fund procedure, which emanates from, my lord, international arbitrations, where you have to, the objective is to seek the truth. So whether something is in your favor or against you, you have to disclose. And
Provided it's relevant.
yes, yes, provided it's relevant, you have to disclose.
And relevance will be judged by you.
Yes. But when you justify that and say that it is not relevant, then, my lord, the stigma of concealment may also, my lord, attach. So, my lord, while drafting a suit in a commercial cause, in the commercial division, it's now like a petition, because you can't disclose without pleading and explaining. So, therefore, it's like a petition. But when we filed this suit, it wasn't, my lord, a commercial suit. So, my lord, all of it was not there. So, when you when an application for leave to disclose document comes up, my lord, some, my lord, leeway ought to have been granted by the learned judge, because this was not originally filed. This is point number one. Second issue, my lord, is that there was no direction that disclose documents now and no further. Peremptory directions apply. So, and there was no case management hearing. None of the parties were really proceeding with the suit. So, some, my lord, relaxation again. And also relevant is that until that order came in 2023, I had no reason or occasion to disclose documents pertaining to other allotments. You know, other allotments, board meeting minutes, my learned friends want me to disclose. They can't say that it should not be disclosed. Documents pertaining to other allotments were only necessary from January 23. Before that, there was no reason. And the judgment of, my lord, the learned single judge in the writ petition, I have disclosed the certified copy. Now, when the matter comes up, my lord, and the rejection happens, my lord, that's at page 846 in volume 6. This is the first order. And I came fast, my lord, within 5 days. So after 23, when it became relevant, nobody was proceeding because of Order 7, Rule 11. I've shown their stand before the commercial court that they wanted a few long days. And then once it's disposed of in Supreme Court, within 5 days I come to court with the application. 846, my lord, 3rd of October 2024, my petition is dismissed. My lord, please permit me to place this order. This is the first.
Thou. 846 thou.
846. Volume 6, page 846. Statement of truth rule.
Yes.
Lord, I'll place the order. After, my lord, from the 4th paragraph, after heard both parties have filed written notes of argument in respect of the application, along with the reported case laws of the Honorable Court, which have been produced, followed and kept with the records. Contention of the plaintiff in the instant application is that initially the suit was filed before the learned civil judge, senior division at Barashat, being titled suit number such and such, subsequently transferred. Then, my lord, initially the suit was not a commercial suit. All documents were not annexed. Documents were to be disclosed as in a regular suit. Then, page 2, after when the suit was started, plaintiff has filed documents as per Order 11, Rule 1, Sub-Rule 2 of the CPC, disclosing only the documents which form part of the disclosures to the plaintiff as indicated in the injunction application. Suit has now proceeded to the stage of peremptory hearing, though no case management had taken place, though there has been an order to that effect. On the next day, that is 12th April, defendant filed affidavit of admission denial along with suggested issues. Issues were framed. Suit was posted for peremptory hearing. At that juncture, officers of the plaintiff started preparing affidavit of evidence with advocates, several documents relating to the present case, and the larger issue involving the allotment of plots under the chairman's discretionary quota at Newtown, which has a huge bearing on the present suit surface, but the same did not form part of the list of disclosures filed by the plaintiff. Now, this was our principal argument, that when my statement of truth is not false, I have disclosed the documents pertaining to this allotment, and I disclosed the judgment of the learned single judge at that juncture. Those were the only documents available. That is enough. The learned single judge's judgment, my lord, discussed the process and the illegality, and, my lord, the documents, my lord, pertaining to this matter. And my statement of truth is, I have disclosed all documents pertaining to this case. Now, when the Supreme Court judgment, my lord, the order came that can't rely upon the judgment, it's not binding, then the requirement arose. But this, my lord, did not find favor with the learned judge. Further contention of the plaintiff is that the defendant has sought to rely upon a judgment of the Honorable High Court in the case of such and such, where 61 writ petitions challenging the cancellation of allotment of plots of land allotted under the chairman's discretionary quota were dismissed by a common judgment and order passed by the Honorable Justice Shonji Banerjee. In the said judgment, there is a reference to several illegalities perpetrated in obtain illegal allotment of plots under the chairman's discretionary quota. The said documents find reference in the said judgment and order, which has been relied upon by the defendant. The said documents are required for complete and effective adjudication of the dispute between the parties in the present suit, and for rendering substantial justice with regard to the allotment of the plot of land in favor of the defendant under the chairman's discretionary quota, which has been challenged in the present suit. Plaintiff has enlisted a series of documents ranging from alphabet A to P, covering several notifications, minutes of meetings. Minutes they also want. Advertisements, guidelines of allotments, which are sought to be disclosed as additional documents in the instant suit. The plaintiff contends that the entire process of allotment of land under the chairman's discretionary quota was arbitrary, illegal, or wrong, and the said illegalities can be detected from the advertisement published for the purpose of notifying offers for allotment of land. The applications were made by the applicants without fulfilling the required criteria, and those were not supported with sufficient documents. Many of the applications were without printed dates, though most of the applications were printed. Many of the applications were submitted beyond the time specified. Said applications were allowed without assigning any reason by the screening committee. Applications were allowed through total non-application of mind, including ignoring guidelines, etc. Plaintiff has proceeded to narrate how the documents of the writ petitions would show the illegalities perpetrated. Plaintiff has referred to different writ petitions mentioning their specific numbers, which were all filed in the year 2012, 13, and 2014. It is also alleged that in some of the application, rubber stamp, etc. Then, Milord, please see the next paragraph. Then we've also mentioned, Milord, those antedated applications. Then paragraph 29 of the instant application dated 13th May, plaintiff has filed a tabular chart mentioning the writ petition numbers, relevant paragraphs of the judgment of the Honorable Justice Shonji Banerjee, his lordship's judgment dated such and such, and the infirmity found in the writ petitions. In spite of several illegalities, the applications were allowed and the lands were allotted as per the chairman's discretionary quota upon change in officer, etc. Then present defendant was a party to 3 writ petition, letter of allotment of the defendant. Whole thing is not noted. Under the circumstances, plaintiff at the bottom of the page, plaintiff prays for leave to disclose additional documents. Then 850, the arguments that only first, my lord, only after Order 7, Rule 11 rejection, this application has been filed. Plaintiff wanted to disclose further documents, and the defendant wanted the plaintiff to disclose further documents. Only on 23rd January 23, when the Honorable Supreme Court of India, in appeal from the division bench, observed that the suit will be determined on merits, DO's observations made against the petitioner that it became necessary for the first time for the plaintiff to disclose documents relating to other allotments, board meetings, minutes, etc. Plaintiff also contends that it cannot be said that there has been delay of 14 years on the part of the plaintiff to pray for leave to file additional documents. Suit was filed in 2014, transferred in 2020, and 2023. Considered documents were not disclosed to be required to be disclosed, and those became required to be disclosed only after the order of the Honorable Supreme Court dated 23rd January 23, after which neither party did anything till 6th May, when the Order 7, Rule 11 was dismissed. Within 5 days thereof, both parties applied together in respect of documents. It was the submission of the learned advocate for the plaintiff that unless the documents relating to the other writ petitions are permitted to be led in evidence in the instant suit as additional documents, ends of substantial justice would be the sufferer, and it would be subjected to the procedural law, which was never the intention of the lawgivers. The contention of the defendant in affidavit in opposition is delay, essentially delay. Let me read. Non-maintainable, filed at belated stage, whole purport is to expedite disposal of a commercial dispute. Commercial dispute is to be treated differently, and it is a distinct class in terms of the provision contained in the CPC. Order 11, Rule 5 specifically indicates that plaintiff shall not be permitted to rely upon documents which were in its power, possession, control, and custody but were not disclosed along with the plaintiff or within the extended period. Only exception to the general rule is that leave of court has to be obtained, and such leave shall be granted upon the plaintiff establishing, this is important, reasonable cause. We cited cases, my lord, that reasonable cause is lower than sufficient cause. Reasonable clause for non-disclosure, such as plaintiff has conducted this suit in negligent manner. Suit was in 2014, subsequently transferred. Even summons was not served, etc., etc. Then, my lord, next paragraph. Considering conduct of the plaintiff, who was not even represented on a few occasions, this court, by order dated 10th March 21, called upon plaintiff to show cause. After the show cause was accepted, plaintiff was directed to complete requisites for service, etc., etc. Then order 7, rule 11. Then, my lord, page 852. Towards the learned judge notes that there was no stay of proceeding. Then, middle of the sentence, plaintiff did not even insist for case management hearing for reasons best known to itself. Suit was posted for case management hearing, but no effective step was taken by the plaintiff. Issues were framed. When an application under Order 7, Rule 11 was rejected before the High Court, subsequently before Supreme Court in such and such, still there was no stay order. Supreme Court by order it is such and such pleased to affirm the order passed by the High Court. There was a direction given by the Apex Court upon this court to make an endeavor to dispose of the suit within a period of 9 months from the date of such order. Plaintiff has filed the application under Order 11, Rule 5, seeking leave to disclose additional documents after 10 years since institution of the suit. Plaintiff has not prayed for amendment of the plaint. These are crucial sentences. 10 years, the learned judge observes, but learned judge doesn't take note of the argument that this was not required till January 23 because of the judgment of the learned single judge. Second, my lord, plaintiff has not prayed for amendment of the plaint. I don't need to. I've said that the process was faulty, and I'm establishing that through evidence. Then, my lord, it goes on. Plaintiff filed a statement of truth on 6 December 22. It has sworn that all documents in power, possession, control pertaining to the facts and circumstances of the proceeding, which is not this matter, this allotment. It's not a false statement. Has been disclosed. Then, the additional documents which the plaintiff is now seeking to introduce were all along within its power, possession, control, or custody. Plaintiff has relied upon the documents in the course of hearing of the writ petition and in the appellate proceeding. In the show cause filed by the plaintiff, it has made several contentions. Among such contentions, one ground is that learned advocate on record for the plaintiff was under the mistaken impression plaintiff has to disclose only those documents which were annexed to the plaint. Several other documents are necessary for effective adjudication. Plaintiff has also contended that the documents annexed with the plaint have been the only disclosed documents due to a miscommunication with the advocate on record and senior counsel. Plaintiff has contended that documents are extremely voluminous. Officers present were no longer in service. The officers who assisted counsel in the writ petitions, they were not there. Herculean task, etc., etc. By then, next page, by introducing additional document, plaintiff is illegally seeking to alter the nature and character of the alleged cause of action of the suit. The defendant's property being such and such has been duly allotted to the defendant. Prior to the allotment, plaintiff has invited offer for allotment of plots, and pursuant thereto, the defendant has submitted an application for allotment of a plot. The application was approved by the chairman on such and such. Allotment was communicated to the defendant on such and such by an allotment letter. Property was meant for development of a mall cum office complex. Defendant has purchased the property from plaintiff at a consideration of such and such. Deed of conveyance was issued in its favor. Defendant was delivered vacant possession. Completed construction. Completion certificate issues. Even defendant has proceeded with construction. Various persons filed. In one of the writ petitions, plaintiff filed affidavit. That Alo, I care, and he is different. Then, Milord, page 850. So, Milord, all of it is considered. Milord, the learned judge in this page, Milord, really feels, Milord, that this is a proper allotment. Then page 855, being aggrieved, 14 among such and such writ petitioners preferred intra-court appeal and advocate such and such. Then suit was filed. Then plaintiff successfully dragged the suit over the years. The defendant has urged other grounds as well as in the written objection at hand, and has also contended that Order 11, Rule 7 CPC applicable to the commercial court has made it clear that Order 7, Rule 14 CPC has no application to commercial suit. As such, there is no scope of producing or relying upon documents by the plaintiff as per the said provision of CPC at a later stage, even with the leave of the court. Accordingly, defendant has prayed for rejection of instant application. Considering facts and circumstances of the suit, plaint along with its annexures filed, material and record, instant application, etc., submissions, it appears both parties have made voluminous application and affidavit in opposition. Both sides have filed their respective notes of argument relying upon case laws. The application is under Order 11, Rule 5, read with Section 151 of CPC. Provision of Order 11, Rule 1, Sub-Rule 4 and 5 have close bearing with each other. Then, Milord, I'm not reading the rules, I'll read it separately. Then, on a plain reading of the said section, it appears that the time to file additional documents in a commercial suit before the commercial court is primarily within 30 days of the date of filing of the suit. But for the same also, the plaintiff is required to seek leave of the court to file additional documents in case of urgent filing. When the said additional documents are filed with the leave of court within 30 days, plaintiff has to swear a declaration on oath stating that it is produced in all its documents in its power, possession, control, and custody pertaining to the facts and circumstances of the proceedings initiated by the plaintiff, and that the plaintiff does not have any other document in its power, possession, control, or custody. Order 11, Rule 1, Sub-Rule 5 of CPC starts with a negative covenant that the plaintiff shall not be allowed to rely on documents which were in plaintiff's possession, power, control, custody, and not disclosed along with plaint or within the extended period, 30 days, except with leave of court, and such leave shall be granted upon the plaintiff establishing reasonable cause for non-disclosure along with the plaint. In the instant case, the additional documents relating to the several writ petitions filed in the years 2012, 13, and 14 were well within the knowledge of the plaintiff. In fact, the judgment of the Honorable Justice Shonji Banerjee referred above was passed on 13th May 2015. At that time, the instant suit was not a commercial suit and was just pending in the court of the learned civil judge at Barashat as a regular civil suit. The documents involved in the said writ petition were not unknown to the plaintiff, and as mentioned by the learned advocate for the defendant in one of the writ petitions, plaintiff has filed affidavit in opposition affirmed on 16th March 2015, stating that the defendant did not fall in a similar circumstances as of those writ petitioners whose allotments were granted from chairman's discretionary quota. As such, it appears that there is no overwhelming fact for suddenly dragging the documents relating to the said 61 writ petitions and the details of meetings, minutes, averments, and notifications therein as additional documents of the suit. The instant suit has come up before this court for disposal as a transferred suit from the Court of the Learned Civil Judge Senior Division at Barashat. Section 15 of the Commercial Courts Act provides that when any suit or application relating to a commercial dispute of specified value is transferred to commercial court, the provisions of the said act shall apply to those procedures that were not complete at the time of transfer. It appears that the instant suit, which was filed on 27th October 2014 before the civil court, was transferred to this court vide order such and such, and the case record was received by this court on 4th September 2020. But till that date, no procedure of suit was complete, not even service of summons. It shows dilatory conduct of plaintiff, having led the suit to proceed without any effective development from 2014 to 2020. And this also indicates that, in fact, all procedures of Commercial Courts Act and amended procedure of CPC were applicable to the suit. But even after transfer, the plaintiff continued in the same vein with its dilatory attitude. Plaintiff was directed to file show cause. It submitted show cause, which was accepted. Thereafter, plaintiff remained busy in seeking several adjournments and contesting application under Order 7, Rule 11. Said application filed by the defendant was rejected by this court by order number such and such, and thereafter both sides had been contesting CO before the High Court and contested the matter relating to rejection of plaint even before the Apex Court, which was disposed of by the Supreme Court by order dated 6th May 24. All along, there has been no stay in the process and proceeding of this suit.
Mr. Chaudhary, we have gone through the order now.
Yes. Last 2 pages, my lord, other reasons. My lord, may I make, my lord, just 2 points? Number 1 is, why, my lord, this is not a finding that there was no stay. So you should have proceeded during pendency of Order 7, Rule 11 is there. Practically, it's impossible. None of the parties, my lord, proceeded. Though it's my suit. But these issues were, my lord, contested. It was understood we were both taking adjournments. Why should I suffer alone? Secondly, what I ask myself the question, my learned friends have also filed an application for disclosure of documents on the same day. That's not dealt with ever. And that, my lord, seeks that I should disclose the minutes of all the board meetings. Next, my lord, is the whole issue of the writ petitions and the documents disclosed in the writ petitions and the judgment being conclusive proof because it's a public matter. And, my lord, order of Supreme Court in January 2020 and how that changes 2023 and how that changes the whole gamut of the matter. Now, that's also not considered at all. And, my lord, this was rejected. Second issue, my lord, is yes, revision pending. Second issue of importance is the section says, my lord, the rule says reasonable cause. It doesn't even say sufficient cause. Reasonable cause is even lower than sufficient cause.
We've seen that the learned judges said that the standard is not too high, reasonable cause, to establish reasonable cause, but it has to appeal to reason. That's the language used. We have read the entire order.
So, my lord, but why doesn't it appeal?
Anyway, yeah, that she has not said. She has said that you were all along aware of these documents right from the stage of those writ petitions. So you ought to have disclosed them along with your plaint. You, at the time of filing your suit, you had no idea whether the writ petitions will succeed or not.
Yes.
So you should have relied on those documents showing that the allotments were illegal. This is what she says, I mean, what we raised.
Now, there's one point, my lord. My learned friend, Mr. Gupta, actually told me this. It's a good point, my lord, which deserves, my lord, some attention, perhaps. This is some form of a penal provision, my lord, which does not, or a restrictive provision, which does not give me free right to, my lord, do something. Now, in respect of a transferred suit, my lord, there is no such provision. These restrictive penal provisions, my lord, in statutes have to be strictly construed. Unfortunately, my lord, this issue is also not addressed. Let us, my lord, see order 11 once. My lord, there is nothing.
Will you continue after recess or?
My lord, when I am, my lord, here, whenever your lordship, whenever matter is taken up, my lord, I can do. I'll come back, my lord. Mr. Banerjee wants to finish, my lord, that matter, where I am his absentee junior.
Which matter?
My lord, that Calcutta swimming club matter.
Oh, I see. Very well, then we'll take this up again tomorrow, day after tomorrow.
I'll be here, my lord. I'm not going.
দেখো
থাক না, আমায় করতে দে না।
we have heard Mr. Chaudhary, learned senior counsel appearing for the appellant, at length. He does not conclude.
We have filed those supplementary paper.
একদম গোড়ায় রেখো। This appeal is directed against a judgment and decree dated January 28, 2025, whereby the appellant's suit for declaration, delivery up and cancellation and injunction has been dismissed by the learned judge, commercial court at Rajarhat. Paragraph, we have heard Mr. Chaudhary, he does not conclude. Paragraph, supplementary paper book filed on behalf of the respondents. We kept with the records. Paragraph, list the matter once again. কবে রাখবো? কালকে রেখে দাও, থাক লিস্টে।
Yes, whenever.
কালকে ডেটটা দিয়ে দাও।
Only one thing may I say. My lord, before the commercial court, my lord, lot of us, my lord, juniors and my lord, that we have a lot of work there. But if there was virtual hearing, everybody would benefit. All courts have virtual hearings, apart from, my lord, the commercial courts in West Bengal. My lord, Asansol court permits. Alipur court also, my lord, sometimes permits.
Is there infrastructure?
My lord, perhaps not.
Yesterday, when I was moving that bank guarantee injunction matter there, I also inquired. My lord, the learned judge expressed that, my lord, the people there are not so tech savvy to, my lord, deal with that infrastructure yet. Maybe they are having some technical glitches there. And as a result, my lord, we are not in a position to appear virtually there.
Like, my lord, NCLT, if there's a cause list, and if it's, my lord, if the link is published on the cause list, it would really benefit, my lord. Sometimes for a 2-minute hearing, you need not travel, my lord, 1 hour.
I understand. এইটা আলাদা করে একসঙ্গে রাখবে লিস্ট অফ ডেটস এর এটা।
It should be more organized, my lord. One person.
We have a commercial committee meeting tomorrow itself.
Please, my lord.
Remind me.
I will. Yes.
Message.
Yes.
Grateful, my lord. Grateful.
ঠিক আছে। হুম। জমা। I'm so sorry, my lord. I had the photocopy. I should have handed it over. না ঠিক আছে, থাক। এটা তো অরিজিনাল আছে জজ সাহেবের কাছে, কিন্তু
We will hear out the appeal. We'll stay the operation.
Can I expedite the appeal also?
Yes, yes. Money receipt, lekho. Money receipt, oblique challan, issued by the cashier, High Court AS, Calcutta, dated June 17, 2025, evidencing deposit of rupees 4,08,900 by by learned advocate for the appellant, be kept with the records.
the original is I have got the photocopies also.
Acha, photocopy of it, original ta ferot diye dao. Photocopy bole of the be kept with the records. Paragraph, we therefore see that the entire decretal amount has now been secured by the appellant. Hence, the order of stay of operation of the decree shall stand reinstated and shall continue till the disposal of the appeal. Paragraph, let requisite number of informal paper books be prepared by the appellant, incorporating all papers that were available before the learned trial judge. Stop, all formalities are dispensed with. Stop, since you represent all the respondents.
1 to 4.
Since the respondents are represented through learned counsel, notice of appeal is deemed to be waived. Paragraph, the stay application stands disposed of. Stop. However, a copy of the stay application be included in the paper book to be filed in the appeal. Paragraph, list the appeal. How soon can you do the paper book?
Lord, we can do it within 4 weeks, my lord.
4 weeks? Why 4 weeks? Informal paper book, just collection of the 2 weeks. যেখানটা বলেছি না requisite number, ওখানে add করে দিও within 2 weeks from date. This is the matter 3 weeks hence. বলে একটা date দিয়ে দাও.
Lord, one more thing, Lord.
ওই stay application being such and such, GA, whatever, IA
Can one.
Yes.
Lord, this money may be invested somewhere.
Yes. Paragraph. Learned Registrar General is directed to ensure that the total amount of how much?
58.
650 plus this much. How much is come?
10,58,882.
900 হয়েছে 10 lakh
10,58,900. That the total sum of rupees 10,58,900 deposited on behalf of the appellant vide receipt number 239 bracket capital A dated May 19, 2025, bracketed the rupees 6, 50, 000, bracket closed, and receipt number 376, bracketed capital A, dated June 17, 2025, bracketed the rupees 4, 08, 900, bracket closed, is invested in an interest-bearing fixed deposit account with a scheduled bank. Stop. The fixed deposit shall be kept renewed till further orders of this court.
Much obliged. Photocopy to Rohit.
Mr. Gupta, you deprived us of the pleasure of
My advocate on record, not me.
Did
He will also the pleasure at the time of final hearing.
any progress in that matters?
But, today they have communicated me the details.
Today.
And it is not in Purvavardhan, it is in Murshidabad. Navagram, Murshidabad.
I see.
Special officer potential.
Item 7.
My lord, I am the appellant in this matter. It is an appeal under section 37 of the Arbitration and Conciliation Act.
This matter has come up almost after a year. If your lordship may kindly fix a date for.
So,
I am ready. I can make my submissions.
Mr. Balodia, don't we know you're always ready? You're ever ready. Union Carbide.
Any day next week, your lordship.
Very well. Not this week. Just on the request made by learned advocate for the. Achha, this Assam Carbon Products Limited. Just tell me one thing, Mr. Sarkar.
Yes.
Does this have anything to do with Rakesh Hemat Singh released? We are not inclined to take up this matter. Hey, Likcho, on the personal ground of one of us. Aman naam ta diye do. Paragraph, let the matter be released, stand released, let the matter stand released from our list and be placed before the Honorable the Chief Justice for appropriate direction.
Item 8.
May it please your lordship, your ladyship. My section 37, preliminary point which, my lord, I'll be taking is, my lord, after 2015, when there was a reconstitution in the tribunal, and my lord, this was railway officers. Point was not taken by us, admittedly, in the course of the proceeding. 4 hearings and the matter came to an end. We have filed a brief notes of submissions, basically a skeleton notes, which we have filed, with the judgments which we are going to refer to.
So, Bag, this is a 37 appeal. It will take a little time.
It will take time.
You have a leader, no?
Mr. Shatru Banerjee, my lord, is appearing. This is that matter which, my lord, we are now armed with that Bombay High Court judgment.
Saying what?
Point, my lord. 12.5, my lord. It's a violation of 12, section 12, subsection 5, because there's nothing in writing. The waiver is not in writing.
I see.
My lord, the section 34, when we had taken this point.
Oh, Bombay High Court and then
And
Vodafone, not Vodafone. BSNL. Very well, Mr.
There
Park.
too, my
Mr.
lord.
Park, please come back. Please come back next week.
We will,
next,
my lord. We will.
next
In fact,
Monday.
in fact, my lord, now I also have a Delhi High Court, which, my lord, says very similar to our case, because we had not taken, the argument is, my lord, we had not taken this point in the course of the arbitration proceeding. My lord, in the Delhi High Court, my lord, in the same similar fact situation, my lord, they had not taken that point in the course of the proceeding, but it's a point of law. So in
Okay.
section 34, this was considered, and 37, my lord, is exactly the order, my lord, which I'm praying for.
Come back on Thursday then, day after tomorrow. Yes, sir. It has just been Thursday.
No, we've also filed a skeleton notes, my lord. I'll refer to the notes and
Yes.
the judgments there.
Just follow the notes. Please the note.
I will.
And that's it.
Keep it very brief, my lord.
Yes.
Deeply obliged.
Order. Item 9.
No, I'm for the appellant.
I'm
appearing for the respondent.
EMD.
9?
কি দেখছি আমি ভুল দেখছি নাকি?
Tonic thermal.
Oh, sorry. Yes. Yes.
The quote can't be wrong, Mulad. So, Mulad, I checked again.
Yeah, I was looking at the non-commercial list.
Sorry, Mulad. This is a matter, Mulad, where Mulad, we had, in fact, I had started my submission on Mulad 16th May at the interim stage. Then Mulad, a suit filed by my learned friends with 24 bills. One bill, Mulad, which we had already paid, and 23 bills surfaced. No date, nothing. Then Mulad wanted to hear out the matter, Mulad, together, because there was no point in Mulad repeating Mulad that whole thing. But only difficulty, Mulad, we faced, Mulad, there was a direction for the lower court records to be Mulad, the trial court, sorry, not the trial court records to be Mulad brought.
Not yet come.
Not yet come. But Mulad, I Mulad requested Mulad, my instructing advocate, that it is because apparently Mulad that had to be compared. But irrespective of that, Mulad, we have the papers. So Mulad, we'll file the paper book, Mulad, but within 2 days. Kindly Mulad keep it, because I don't want Mulad. They will then start Mulad execution, and then Mulad all this Mulad will, because at that time Mulad, that is why Mulad fixed it.
We'll do that. We'll do that. Nonetheless, we have to see why the TCR has not come.
Mulad, we put in the requisition, Mulad, on 20th of May. This is Mulad.
You'll file within 2 days.
Yes, yes.
Lekho.
By Friday, we can
Friday.
Copy. Yes. Tuesday, Friday.
By Friday, then next Tuesday.
Next Tuesday.
Next Tuesday it will be listed.
Yes.
But by Friday they'll.
Friday dile hobe. Aki paper.
I'll need a couple of days to read.
On May 16, 2025, we had directed, inter alia, that the trial court records be called for. Learned advocate for the appellant says that he had put in requisition, what do you call it?
Requisition.
Special messenger cost, Mulad.
Special messenger cost on May 20, 2025 for expeditious transmission of the trial court records to this court. However, it appears that the trial court records have not yet come to this court. Paragraph, the registry shall file a report as to why the trial court records are still not available before us. Paragraph, the appellant will be at liberty to file paper book, informal.
Yes, Mulad.
Informal paper books by Friday date
20th.
In terms of our order dated May 16, 2025. Next, let's list the matter under the appropriate heading on Shamner Mongolbar ittadi diye daw. Check up your diaries, respective diaries.
24th, I think, Mulad, 24th June.
It is 24th June.
24th June.
Not 24th August.
No, Mulad. Good date, but may not be the right. It is right month, Mulad, for others. after
trial
23rd
court
June.
records will be required at the time of hearing. If it
We
is
have
not
asked for a
done,
report. Director Lekho, the registry to ensure that on the adjourned date, the trial court records are available before us.
because it is an informal paper book, but if
Yes.
something is to be tallied with, not the TCR will be. I'm grateful.
Great. Great.
Can discuss. Can to dispose কথা কিছু বলেন? Can থাকবে? থাকবে আগে অর্ডার আছে। ওগুলো নিয়ে নাও। Non-commercial matter, item number 1.
I am appearing for CBI led by Omojit Dey. I am paying for password.
Item 2.
Why? Oh, assigned.
Assigned, my lord.
When do you want it? Tell us.
My lord,
You are the appellant, Mr. Mukherjee?
yes, my lord, we appear, my lord, for the appellant. There is some interim protection in our favor. But my lord, at the end of the day, my lord,
There's some English smell in the air. Anyway, yes. What is it?
my lord, I'll keep it.
My lord, additional 1 week, my lord, always has that, my lord.
Yes. So tell us when you want it.
My lord,
Earliest Karuna, matlab, we are
yes,
suffering on it.
my lord, as a
Lord, I am being led by Mr. Bachawat, my lord. My lord, if your lordship can take up any day after the week, my lord.
next Tuesday. My lord, after 2 weeks also, my lord, English, my lord, scent can be there.
No. Thakte kore daw, next week.
My lord, next
Tuesday
week, my
kore,
lord,
next
next
No, not
Tuesday.
this week.
Next Tuesday.
Next Tuesday, my lord.
Let this next Tuesday. This matter has been assigned to this bench. Let this matter be listed under the appropriate heading, application or hearing, or what is it? What stage?
My lord, it's actually, my lord, hearing of the appeal. I'll tell your lordships what had happened. My lord, a writ petition had been filed challenging grant of a way leave permission, my lord, in favor of my client to run a closed industry. My lord, that was challenged by the writ petitioners. It was set aside according to us on grounds not even made out, my lord, in the writ petition. My lord, the railways, my lord, the allegations were against the railways who granted the way leave permission, my lord, to take, my lord, a water pipe to supply water to a closed industry. Now, and which had been existing before. Now, my lord, after having, my lord, the way leave permission was set aside, we went up on appeal because there was a demolition form, my lord, order for demolition of construction already done pursuant to way leave permission being granted. That was stayed, my lord, by the division bench. Division bench wanted an affidavit to be filed by the railways whether they had conducted an independent survey to find out if the structure was safe. Railways has filed an affidavit, my lord, saying, my lord, that they had conducted an independent investigation, that it was safe. There's a challenge, my lord, to that report of the railways. And, my lord, all affidavits are complete. It's really, my lord, the matter, my lord, which was being, my lord.
But there is no paper book as yet.
No paper book. My lord, there's extreme urgency.
No, fine. All papers are before. You are for, Mr.
For the other side,
Railways is not a party.
Railways is
It's
also
party,
here.
party.
I'm the writ petitioner.
Yeah.
Complete collusion and fraud is discovered. As a result, these orders have been passed.
My lord, we'll see.
Complete fraud.
Next Tuesday? Next Tuesday?
Yes, yes, my lord, fine.
কি লিখলাম assigned to us, huh? হ্যাঁ ওই next Tuesday appropriate heading মানে হচ্ছে hearing এ দিয়ে দেবে হ্যাঁ ব্র্যাকেটে দিয়ে দাও for hearing হ্যাঁ next ডেটটা দিয়েছো stop we are told that all papers that were available before the learned single judge are before us and hence we propose to hear out the appeal
And pending applications.
and the connected applications. Yes.
No difficulty.
My lord, it's at 2 p.m. my lord on Tuesday or my lord?
No, Tuesday the appellate side is in the first half. I mean, we start with appellate side.
Yes.
But commercial, non-commercial,
This is non-commercial, my lord, which is why.
Commercial is over, you're done.
So, my lord,
non-commercial প্রথম দিন কোনো দিন আছে এরকম হয়, then Thursday. If you want it first, then Thursday week.
yes, my lord, that's fine.
তাহলে শোনো, Thursday weekend ডেটটা দাও।
My lord, let it be Tuesday, my lord, we'll do it.
Normally there aren't too many matters on the appellate side.
But it will be towards, my lord, the latter half.
Yes.
Your lordship has both.
No.
None. He is there also. My lord, let it will be there, my lord, let it.
The chances.
No, my lord, the industry is suffering, my lord, otherwise, my lord. So, my lord, after having succeeded, my lord, in the resolution plan, and they were, my lord, H2. They have now ensured that, my lord, we, my lord, cannot, my lord, after winning there, my lord, in, my lord, in the resolution plan bidding process, my lord, they have now, my lord, decided to scuttle it.
Yes,
Absolutely no connection between.
I'll show that, my lord.
they are saying collusion and pollution both.
And illegality.
Mr. Mujumdar is assisting you.
Mr. Bachawat is leading me.
Very well.
24th.
24 তারিখ
এই 24 তারিখই রাখছো? হ্যাঁ 24, দুদিন পেছিয়ে যেতে বললাম, ওটা করো না, 24ই থাক।
Item 3.
This is my application, Millet. Pursuant to my Lord's direction of 6th May, Millet had passed directions to file affidavits, Millet. We were in receipt of the opposition on 21st May, Millet. The person who was going to sign the affidavit, Millet, is since traveling. I am told he is going to come back to the city on Thursday, Millet. May this matter then stand over on Tuesday next, Millet. In the meantime,
I'm
I'll
waiting for the private respondent.
You're for?
For the Ruya Chemicals respondent.
the respondent, Millet.
You want it Tuesday, next Tuesday?
Yes, Millet.
24th.
Sorry, Millet.
24th. You'll file your reply.
Yes, Millet.
You are
I'm filing my opposition.
affidavit lekho. Affidavit in opposition filed on behalf of all the respondents.
No, Millet. They are only for respondent number 1.
On behalf of the respondent number 1, be kept with the records. Paragraph, learned advocate for the appellant seeks accommodation.
Second copy.
Stop on her request. Comma, let this matter be listed again on June 24, 2025. Stop. In the meantime, comma, the appellant will be at liberty to file affidavit in reply with advance copy to learned advocate for the appearing respondent.
I'm obliged, Millet. Deeply obliged.
My lord, I have.
Why?
My lord, it's in my office. My lord, within 10 minutes.
In course of the day. Huh?
এটা থাকবে?
Item 4.
Item 4, my lord, I am for the appellant in this matter, my lord. My lord, the problem that has happened, my lord, the appellant company management has changed very recently, my lord, as for did not obtain the instruction.
Saying that I'm for the plaintiff who is opposing. He's saying that his management has changed. He's for the appellant. I'm for the respondent plaintiff.
What is he asking for?
I think he's asking for some
And
time.
I'm asking for 2 weeks time, my lord, 2 weeks time.
2 weeks
2
time.
weeks instead of 2 weeks, make it 1 week because I am suffering an interim order. Make it
10 days, then 10 days at least.
Tuesday, a week's adjournment.
Learned advocate for the appellant seeks accommodation on the ground that the management of the appellant company has changed. Paragraph, learned Mr. Sharma, learned advocate, then senior advocate for the respondents.
Plaintiff. Respondent plaintiff. My suit has been stayed.
Only one respondent. Who are the others?
All of them.
Respondents / plaintiffs says that his client's His clients are suffering an interim order. Paragraph, list this matter once again on June 24.
Deep privilege.
Item 5,
application for restoration. Well, this is my affidavit of service.
I appear for the respondent. My lord,
My lord, I have stated in my, your lordship kindly, in my petition, paragraph 5, 6, 7, due to, my lord, it was page 4 of your lordship's brief. Page 4, your lordship's brief. Paragraph 5. Taken up on record thereafter direction given for service effected but the record was getting married for which she was not available at that point of time. Then my lord kindly come to page 5, paragraph 6. Learned advocate was conducting the matter other than the learned advocate record. Father had fallen ill suffering from pneumonia. There are a lot of personal difficulty and this coupled with the FMA number of given learned advocates and also their clerk missed the fact matter was listed.
there was non-appearance on their part. I am the award holder. I am this at the suffering instance. Kindly, your lordship fixes a date.
No, is there an interim order?
No.
Execute your award.
Pending because of this pendency.
We'll make it clear.
My lord, kindly. And well, a small issue, can it be decided later by fixing a date?
When? Come back day after tomorrow?
No, next week. Next week.
Hey, Yeshu.
My lord,
next
kindly.
Next Tuesday, we'll keep it next Tuesday.
Direct them to serve the copy of the appeals because earlier some other set of advocates were appearing. Now after this, I have been appointed. I do not have the papers.
Appeal papers you don't have. Mr. Chakrabarty, give him appeal papers.
Obviously.
This is an application for restoration of FMA 223 of 2025, which was dismissed for default on February 18, 2025, along with the connected application being CAN 1 of 2024. Paragraph. Having heard learned affidavit of service study Paragraph. Having heard learned counsel for the parties, we are satisfied with the explanation furnished for absence of learned advocate for the appellant on the day the matter was dismissed for default. Paragraph. Accordingly, the order dated February 18, 2025, is recalled, FMA 2023 of 2025 is restored to its original file and number along with CAN 1 of 2024. Paragraph. CAN 2 of 2025 is disposed of. Paragraph ever appeal ta now or we CAN 1 ta now. Learned advocate for the respondent says that he has been newly engaged. As requested by him, let copies of the appeal papers be made available by the appellant to learned advocate for the respondent by tomorrow. Tomorrow date ta diye dao, by kalke date ta. Paragraph. This is an appeal under section 37 of the Arbitration and Conciliation Act, 1996. Whose 34 was, who filed 34? Dismissed. The appellant's application for setting aside an arbitral award under section 34 of the 1996 Act was dismissed by the impugned judgment and order. Paragraph. List this matter once again on Shamner Mongolbar, next Tuesday.
Next Tuesday.
Deeply obliged. You can see the execution case.
Wait till next Tuesday.
Very good.
Deeply obliged.
Great. Item 6.
Lord, item 6, Lord, I am appearing for respondent number 2. Lord, I have received the brief yesterday. Lord, I pray for 1 week time.
Who is for the appellant?
Mr. Shakoshen is joining virtually.
Anyway, he is asking for time next Tuesday.
For respondent number 1.
On the
My lord, we were directed to serve upon the defendant number 2. Probably that service is complete.
they are appearing today. Today they have appeared, Mr. Sen.
Very well, my lord. Oh, well, Mr. Tiwari was appearing. He had requested me for some time. He was playing for some time, and let it appear on Thursday because we are well, on the process of seeking an interim order. My lord. That is, kindly keep it on next this day after
You are
tomorrow.
led by
my lord,
Mr.
we shall-
Tiwari. You are led by Mr. Tiwari. Learned advocate for the respondent number 2 says that he has got the papers yesterday, so he was requesting for next Tuesday. What do you say?
I'm sorry, I could not.
Learned advocate for the respondent number 2 is requesting for next Tuesday.
But actually, as your lordship heard the matter, respondent number 2 has no role to play. It is between us and the defendant number 1, who is the respondent number 1.
Let it come on Thursday. We'll see.
Yes,
Wait,
my lord, kindly let.
On the request made by learned advocate for the respondent number 1, because Mr. Tiwari wanted time, he tells me.
Yes.
Let this matter stand adjourned and be listed again on Porshu Tajida.
And the affidavit of service be kept on record.
Affidavit of service.
Obliged, lord.
Why?
Carrying only one copy, my lord. I'm carrying only one copy, my lord.
No, why are you having only one copy? How many judges do you see before you?
Lordship, I apologize to your lordship.
Get another copy in course of the day.
Lordship, I shall.
You are for the appellant.
Lordship.
Yes. Unless you file in course of the day, your appeal will stand dismissed.
I shall.
With costs.
I shall.
Assessed at rupees 1 lakh.
Lordship, I shall.
Item 7.
I appear for the state respondents.
Lord, I'm
Huh?
appealing for the private respondent. Appellate.
7. Whose appeal? Review. Review.
My appeal. Lordship, kindly Lordship takes up the order once.
You were the appellant or respondent?
The petitioner, I'm the petitioner. My lord.
It was allowed. Against that, they preferred. They are the writ petitioner. The writ petition was allowed. Against that, I preferred the appeal. Appeal was allowed. Against that, they filed this. And in terms of your lordship order, I have already, my lord, filed the affidavit of opposition. Municipality
Before the learned single judge.
Judge, your lordship directed me to file affidavit in opposition. In terms of your lordship's order, I have filed the opposition.
Before the learned single judge, that is what we are asking. Yes.
They have received the copy.
What remains? We have remanded it after setting aside the order. Review. Why review?
My lord, I have been, my lord, briefed, my lord, very recently, my lord. After it came back to my lord, this was also my opinion, my lord. My lord,
No.
my lord, kindly, my lord, disposes it, my lord, with this.
Yes.
That, my lord, opposition and reply, my lord, both have been filed.
Both have been filed.
Both have been, my lord. My reply has also been, my lord, taken on record.
Very
now, my
well.
lord, only thing left is, my lord, the writ to be heard out, my lord.
Very well. Very well. Issue. Issue.
My lord, kindly, my lord, does not record my lord.
No. This review application is directed against an order dated June 17, 2022, whereby MAT 884 of 2022 was disposed of by us along with CAN 1 of 2022. Paragraph. The appeal was directed against an order dated June 7, 2022, whereby a learned single judge disposed of WPA 6879 of 2022. Stop. The operative portion of the order impugned in the appeal reads as follows. এই অর্ডারটাতেই সেট আউট করা আছে, যেটা অর্ডার আন্ডার রিভিউ, হ্যাঁ, থেকে অ্যাকর্ডিংলি থেকে হিয়ার অফ দিস। Paragraph. Having heard learned counsel for the parties, comma, we were of the view that there may be serious factual disputes between the appellants and the respondent/writ petitioners, respondent/writ petitioner. Stop. We therefore, we noted that the writ petition was disposed of by the learned judge without calling for affidavits. Stop. We were of the view that the writ petition should have been disposed of upon exchange of affidavits. Stop. Hence, we had set aside the order under appeal and remanded the matter to the learned single judge, having determination in the matter after directing exchange of affidavits. Stop. Paragraph. Learned advocates for the parties apprise us that in terms of the order under review, comma, the parties have exchanged affidavits before the learned single judge. Stop. The writ petition is ready for hearing. Paragraph. We do not find any error apparent on the face of the order under review. Stop. No ground for review within the scope of Order 47, Rule 1 of the Code of Civil Procedure has been made out. Stop. Paragraph. Hence, comma, we see no reason to review the order dated June 17, 2022. Stop. The review application stands dismissed. Is there any connected application? No. No. Review application being RVW stands dismissed. Paragraph. The parties will be at liberty to mention the matter before the learned single judge, having determination for hearing of the writ petition.
Did my lord, I am appearing on behalf of the petitioner, my lord.
First time?
No, my lord. My lord, in pursuant to your lordship's direction, my lord,
Are you filing your reply?
No, my lord, that has not been.
You want to file reply?
It is not necessary, my lord. Not necessary, my lord. My lord, the contender, my lord, complied the part of your lordship's order, my lord. My lord, in pursuant to your lordship's direction, the contender, my lord, passed self-demolition order and directed to demolish the building, my lord, illegal construction within a period of 15 days. But my lord, 15 days already has been elapsed, but no steps has been taken by the contender.
So tell us what we should do. The contender is not here before us today also.
If your lordship kindly see the order, my lord.
Where is the self-demolition order?
Page 33 of the affidavit filed by the contender.
Page 33 of the affidavit. Affidavit.
What is, my lord?
33. Maju Gram Panchayat.
Yes, my lord.
Pradhan, Mrs. Tutul Kaur.
Yes.
24th March 25. Order?
24th March 2025. My lord, middle portion, my lord, Ali Hafiz পিতা শেখ আলিবুদ্দিন যে গৃহ নির্মাণ করিয়াছেন, যাহা বিগত 25th May 2022 তারিখে ফিজিক্যাল ইন্সপেকশনের সময় সত্য বলিয়া দেখা গেছে, তা অবৈধ এবং পঞ্চায়েত আইন অনুযায়ী আলী হাফিজ পিতা শেখ আলিবুদ্দিনকে ওই নির্মাণ নিজ খরচায় ভেঙে ফেলতে বলা হয়েছে আগামী 15 দিনের মধ্যে। পশ্চিমবঙ্গ পঞ্চায়েত আইন 23 সাবসেকশন 5 ধারা মতে অর্ডার কপি এসডিও হাওড়া সদরকে ফরওয়ার্ড করা হইল for taking necessary action in accordance with the land.
Now you show us the order of which you are alleging violation.
My lord, kindly come to page 28 of my contempt application. Relevant portion, my lord. Page 28, inner page 3. My lord, middle portion.
So reasoned order has been passed.
Reasoned order has been passed, my lord. The decision so taken shall be communicated to the parties
Also communicated to
within a week from the date of decision. Needless to say, if the respondent number 7 finds merit in the complaint
very
made
well.
by the present appellant,
We will dispose of this application by directing the contender now to demolish at the cost of the that what Habibur.
Yes, my lord.
Huh?
Yes.
Learned advocate for the now the alleged contenders are not represented today. Paragraph. Learned advocate for the petitioner says that it may not be necessary to file affidavit in reply. Stop. The contender, the alleged contender being the Pradhan of Maju Gram Panchayat. The alleged contender number 2 karo, number 2, being the Pradhan of Maju Gram Panchayat, has partly complied with the order of this court, violation of which is alleged in the contempt application. Paragraph. We find that the order in question, we find the operative portion of the order in question reads as follows. Of the order in question dated August 2, 2022, whereby MAT 1034 of 2022 was disposed of, reads as follows. Page 28 of the content petition, bracket kora ache. Paragraph. We find from the affidavit filed by the alleged contempt number 2 in response to the rule, bracketed is of page 32, 33.
33 of the
33,
affidavit.
Bracket closed, comma, that the alleged contempt number 2 has passed an order dated March 24, 2025, recording that unauthorized / illegal construction has been detected at the instance of the person responsible being Habibur Rahman.
No, my lord. Ali Hafiz.
Ali Habib. Sorry, Habibur is your client.
Yes.
Being Ali Habib.
Hafiz.
Ali Hafiz. Ali Hafiz. Stop. By the said order dated March 24, 2025, the alleged container number 2 as Pradhan of the Maju Gram Panchayat, called upon Ali Hafiz to demolish the unauthorized construction within 15 days. Stop. It further appears that a copy of the said order, which is really a self-demolition order, has been forwarded to Ali Hafiz and the present petitioner. Paragraph. Learned advocate for the petitioner says that although 15 days period has elapsed long ago, neither has Ali Hafiz, Hafiz হচ্ছে HAFEZ, বুঝেছো? HAFEZ. Ali Hafiz demolish the unauthorized construction, nor the panchayat has taken any step. Paragraph, we direct the Pradhan of Maju Gram Panchayat to demolish the unauthorized construction raised by Ali Hafiz, comma, following due procedure, comma, at the cost of Ali Hafiz. Stop. We clarify that the Panchayat will be at liberty to recover the cost of demolition of the unauthorized construction from Ali Hafiz.
Right.
Stop. Let that exercise be carried out within a month from the date of communication of this order by the petitioner to the Pradhan of Maju Gram Panchayat. Paragraph, with the aforesaid directions, comma, the contempt application stands disposed of.
Grateful, Your Lordship.
Rule stands discharged. এটা rule ছিল।
Item 9.
My lord, item number 9. We are appealing for the appellant, my lord, being led by Mr. Novokumar Das, my lord.
Finally, I have obtained the instruction from my client, my lord.
Can you see the last order, my lord? I have served the notice upon my.
They are not willing to proceed, my lord.
Who is for the appellant?
I am for the appellant, my lord.
You are not willing to proceed.
Respondents, the legal heirs of the respondent, they are not willing to contest, and they have sent a mail, my lord. Last occasion, I requested them to cause a letter upon me, but they have sent only mail. They are not at all interested because their father died. They don't want to contest. So yes.
So it was your writ petition.
No, suit.
It was your writ petition. Must be
Suit.
Suit. It was your suit.
Arbitration appeal. This is
Arbitration.
Arbitration, my lord.
arbitration appeal.
You obtain an award or what?
Yes, awards are on favor of the respondent.
In favor of your client.
Yes.
That award was challenged by them.
My lord.
Yes.
Section 34.
Yes,
My lord, my lord.
Section 34 dismissed. Therefore, this appeal.
My lord.
Yes.
No, even if you don't contest, we'll have to decide the challenge then.
My lord.
Yes, my lord.
We will
The
have to,
last
because
question.
they are challenging the award.
Yes, my lord. The time.
So if you say no, you give up the award, then everything comes to an end.
My lord.
You're not contesting, please understand.
Yes, my lord.
You're not contesting will not actually put an end automatically, because they are challenging the award. Even if you don't contest, the award remains in your client's favor. And they are saying it's an illegal, wrong award, erroneous award. So if you say no, we money award.
Money award.
Money award.
You have received the money, no?
No, my lord. The money is
Deposited in Registry General.
deposited with the Registrar General High Court, Calcutta, my lord.
15 lakhs.
15 lakhs. Already deposited, my lord.
So you want to give that up or what?
My lord, they are not willing to contest yet. They are not giving the
They don't want the money also.
Kolkata also. No, they are no, my lord. They are not at all interested because their father passed away. They are not at all interested. I try to convince them, but they are not at all.
দিচ্ছি নামটা।
No, তো অ্যাওয়ার্ডটা চাইছি, ও তো বলছে আমি কন্টেস্টই করবো।
বোঝাবার চেষ্টা করেন। Convince not.
আপনি মেরিট টেস্ট করবেন তাহলে রেসপন্ডেন্টকে আপনি কোলাপন
Very true. You are prepared today?
Mr. Novokumar Das is appearing senior.
We'll have to hear them, sir. We'll have to hear them.
Keep any day, my lord.
Day after tomorrow.
Day after Thursday. Next week, if your lordship.
Tuesday.
My lord, one thing, my lord, pursuant to the last order, we have already served the notice. Can you record?
On whom?
Learned advocate for the respondent.
They're appearing.
But this is my record because the last order there was a direction, my lord, upon the
Pursuant to our earlier order, comma, a learned advocate for the appellant KMDA has served notice on the learned advocate for the respondents. Stop. The respondents are represented today. Stop. Paragraph. Learned advocate for the respondents produces copy of, it's an email.
Yes, mail.
Email from Hillul from the respondents, addressed to learned advocate, to their learned advocate, which reads thus. Line. Paragraph. Learned advocate says that in view of the aforesaid, he is seeking leave to retire from the matter. Stop. Such leave is granted. Paragraph. Nonetheless, the challenge to the arbitral award remains. So we will have to hear the appellant. Paragraph on the request of learned advocate for the appellant, let this matter stand adjourned and be listed again on June 26, next week, Thursday. You need not come. We have granted you leave to retire.
Item 10.
It's for the appellant.
I'm for that.
Mr. Ghosh, repeated defaults. There is no error in the order.
No, only once default.
Repeated defaults, indulgence granted by the promoter.
The property has been sold off.
As you understand, that property has been sold off. As you can understand, we have read everything.
Yes. But not the kindly see what is the ground for refusal.
What do you want? Specific performance?
Relief not paid for the arbitrator.
No, we prayed for that flat was allotted to me.
Yes.
Deposited everything.
Flat is gone. So today you can't get the flat.
Then Lord, I will be entitled to compensation and I get money.
You may be entitled to whatever you have paid if as per terms of contract.
Yes.
You can.
And Lord, kindly see that is totally malafide. And Lord, the learned arbitrator has
You
found.
are a busy doctor. That is what you say. You are a busy doctor.
So.
You forgot to deposit the installments.
And subsequently, Lord, everything was deposited, and on technical ground that it was not cash deposit, it was a check. On that ground, it was refused. And they took the plea that the notice, from the date of notice, calculation should be made regarding the limitation, 15 days. But it is in the clause, it has been from the date of receipt, not from date of issuance. They have taken that stand. Subsequently, the arbitrator has also admitted that position. But Lord, the Section 34 court has not at all considered anything. Simpliciter, Lord, refused the claim.
No, has considered. We have seen, we have read it. Considered the Paritosh arbitrator's award, discussed it.
No, Lord, that question has not been discussed. The simple question, Lord, whether it has been timely deposited or not.
Mr. Ghosh, the arbitrator, we are not an appeal court. You are not in appeal. Very limited scope of interference in Section 34 and equally in Section 37. Argue your case, cost may go up. Yes, Mr. Ghosh, tell us. We are not inclined.
Lord, your lordship, then kindly take up next Tuesday.
Next Tuesday? Very well. On the request, Lekho. This is an appeal under Section 37 of the Arbitration and Conciliation Act, 1996, challenging challenging an order dated 18 October or 3rd October, what is it? The impugned order? October 3, 2015. Oh, 18 may be the order number, 18.
Yeah, must be the order.
October 3, 2015, whereby the learned district judge, North 24 Parganas, dismissed the appellant's application under Section 34 of the 1996 Act, being arbitration case 185 of 2014, in which he had challenged an arbitral award dated
The award is dated 14th of August 2014.
August 14, 2014, passed by a learned sole arbitrator in an arbitration between the appellant and the respondent, the appellant being the claimant therein. Paragraph. Sentence to the kilometer number. Paragraph. On the request of learned Mr. Ghosh, learned senior counsel representing the appellant, let this matter stand adjourned and be listed again on June 26. Next week, Thursday. No. Tuesday is already very congested.
Only one humble submission, Mr. Lordship. Is it your Lordship's pleasure to record that the property has already been dealt with?
Paragraph. We put on record the submission made on behalf of the respondent that the flat in question has already been sold by the respondent to a third party.
Great.
With my lord.
Item 11. My lord, in this matter, I am appealing for the petition.
Item
Lord,
number
kindly take the matter on next Thursday because I am briefed yesterday evening.
Sorry, you are?
Briefed of this appeal.
Oh, you have been briefed recently. On the request made by learned advocate for the appellant, let this matter stand adjourned and be listed again on 26 Kureda. This is appeal against what, Mr. Devnath? Huh?
Section 9.
Section 9. Refusal of Section 9?
No.
Against you. Against you.
Challenging of that 37, I have filed. My Lord Justice Sanjeev Banerjee and my Lord Justice Kaushik Chandra was pleased to stay the entire order. And thereafter, my Lord, the matter appeared before my Lord Justice Bhattacharya division.
You are enjoying an order of stay?
Yes.
You are for?
But the pro forma respondent.
Oh, who is the real respondent?
SVG.
Construction Private Limited. Very well. Serve a notice. Ask your junior to serve a notice.
After notice also.
When did you serve notice? This is an appeal of 2020.
2020, 18 January was served. But it is left.
No, serve again. Serve again. In the meantime, Lekho. In the meantime, paragraph. In the meantime, learned advocate on record for the appellant shall serve a notice on the respondent number 1, intimating that this matter will be listed on June 26.
Along with the stay petition.
Stay have not served yet.
Served it.
Come back. Very well. Notice along with the appeal papers. Stop. We are told that the service that was attempted earlier has failed and the envelope has come back with the endorsement? Left. Then how will you serve? We don't know. Find out. Give your appearance.
Item 12.
কিচ্ছু যায় না ডাকো ডাকো
Item 12.
Lordship, this is my appeal. Lordship, today I will start. Your Lordship,
Today?
Today I'm going to start. I have a leader, but
Yes, you can start.
Lordship. Brief.
এইটা আছে ক্যালকাটা সুইমিং ক্লাবটা না
Will take some time, Your Lordship. This matter will require.
Yes, start.
Lordship, briefly describing the facts before Your Lordship. The facts related to that, we have issued a tender. They have qualified in the pit. And after that, work was going on.
Mr. Shakushen is leading you.
No, my lord, I am for the yes, I am for the respondent award holder.
Where are you?
Can
Anyway,
I say that
don't want to know. We don't want to know, but then we are adjourning it for the day. This virtual thing, Mr. Sen, doesn't suit me at least.
Very well, very well. No. But if it comments, my lord, my learned friend can finish his argument.
So you better come. Better you come.
Very well. I shall.
With your experience, although you're on the other side, you can still guide him.
I will interrupt him, my lord, by being there personally. Because the way my learned junior friend started as if it is a first appeal, just to mention it, well, it is a 37 appeal. 34 has been dismissed, so just that is the background item.
Not today.
Lordship, one humble request is that if Your Lordship kindly keeps it on the next week, Your Lordship.
Yes, tell us when. Next Thursday week. Thursday week. Appellate side.
And this matter was also dismissed sometime, my lord. Then it was restored on mentioning. So, my lord, let us understand, my lord, my learned friend will do it on next Thursday when Your Lordship is fixing it.
But then on the principle of equality, Mr. Sen, if it was once dismissed, then this time it should be allowed.
No, dismissed for default. not on merit.
Treatment of parties, Your Lordship.
Chalo.
Passover matter, item number 1.
Yes. What is this matter? Why assigned to us?
Lordship, presently it becomes infractious as because the order was challenged before the apex court. State has preferred the appeal. Lordship, Honorable Apex Court has set aside the order passed by the.
Oh, infractious. How wonderful.
Kindly see this is the order of the Honorable.
No, you challenged the order of the learned single judge before the division.
CBI has challenged the order passed by the then Honorable Chief Justice Prakash Srivastava and Justice Rai Chattopadhyay. Against that, Lordship, contempt was filed, Lordship. CBI filed the contempt regarding transfer of one investigation pertaining to that investigation proceeding.
So the order of which violation is alleged in the contempt application has been set aside by the Supreme Court. That is all we need to know. Mr. You have told us that is enough.
No, Lordship, kindly
keep it on record.
Lordship,
yes. learned advocate for Central Bureau of Investigation, says that the order dated
March 28, 2023.
March 28, 2023, violation of which is alleged in this contempt application, has been set aside by the on March 20, 2023, passed in WPA bracket P number 82 of 2023, has been set aside by the Honorable Supreme Court by a judgment, by an order dated April 13, 2023, in Criminal Appeal number 1106 of 2023. Stop. Let a copy of the said order of the Honorable Supreme Court be kept with the records. Paragraph, in view of the aforesaid, the contempt application becomes infructuous. Stop. CPA in such and such stands disposed of.
So one thing, original criminal special leave to appeal criminal number 4430 of 2023. It has been written.
Criminal appeal bole bracket arising out of je dewa ache order ta.
Grateful.
হয়ে গেছে হয়ে গেছে কেউ নেই
সবাই কোথায় চলে গেল?
লোডিং আবার করতে হবে।
No, that will be but exhausted.
Original side non-commercial, I've been number 1 to 5. I am appealing for the appellant. Yesterday, I could not be present in the first call. I'm very
Yes,
sorry.
this was dismissed for default yesterday.
Mr. Sen's 2 matters have been dismissed for default and thereafter being brought back to the 5.
Yes, but we didn't dismiss it.
Yes, it was my mistake, madam. I tender my apologies.
Nobody else is here.
No, Mr. Sen is there.
Yes.
Virtually, it won't suffice.
Yes. But then let it retain its position. We'll come back next tomorrow as the original side day, my lord. We'll take our chance.
Not today.
Oh, my junior is there, my lord. Let him argue. He is there.
My lordships, there were 2 orders, earlier order, lordship, on 16th April, my lord, I had opened the appeal. And thereafter, my leader.
Oh, this is the Jaipur property?
Yes, Jaipur property. And thereafter, my leader, Mr. Surojina Mitra, had continued on the next day. And lordship had heard it. Now, thereafter, because of the summer vacation, there was a gap. So now my.
Oh, it was the other bench.
So I have to start afresh.
You can do that. It's your choice. You can either start afresh or we can release it from our list as we are.
I was only praying one thing because Mr. Mitra is not, I didn't have the occasion to speak with him. Kindly today only make it not today. I will speak with him.
Speak with him because a couple of other matters where Mr. Mitra is appearing, which were substantially heard by the other bench, we have released and we have recorded in the order that it was substantially heard by the other bench so that the matter can be assigned to that bench.
But your lordship.
pass the same order then.
But
Because
only thing, my lord, anyway, my lord, your lordship had heard that matter along with Justice Rai quite some time back, my lord. Anyway, my learned friend will have to start afresh, my lord. Kindly, I think if you let us, if it's
because I
comments
think
to your lordship.
Because
they have already obtained an interim order from the Jodhpur Execution Court. They have already
No,
obtained.
it's not a question of interim order. Kindly have a
Tell
look
us,
at the
what
date
you
of the
want.
award.
Want a not today for the time being, not today.
No, kindly make it not today for the time being.
Let the adjournment be recorded on their ground because
Yes,
they are taking
on the-
adjournment.
on the-
they are proceeding with that. They
on the request made, on the request made, এটা কি একসঙ্গে হচ্ছে ইয়ে?
Both, all five, 1 to 5 together.
Yes, my lord, all
Behalf of
together.
the appellants, let this matter stand adjourned for the day. দেখো next. Let these matters, পাঁচটা তো একসাথে।
Item number 6 and 7.
Tender my apologies, Your Lordship. Lordship, this is my appeal. Lordship, before we proceed with the appeal, the appellant, Your Lordship, pending the appeal passed away. So I have filed an application for substitution. It has been served. And Your Lordship, he has also been substituted in the main matter, in the execution matter. And
আছে application?
Lordship, application GA2.
My lord, before my learned senior friend proceeds, my lord, in the cost title of the substitution application, I find that name of Mrs. Shweta Banerjee is appearing. Her name was expunged long back on 3rd of August 2021 by the executing court. May I hand up the order?
I'll come to that.
My lord, at page number 2 of the cost title, respondent number 4, Shweta Banerjee, her name was expunged.
Judgment निकाल judgment कहाँ है?
In the cause title?
Yes, cause title of the
Lordship, I tell your
substitution
lordship.
application. Can 2, my lord.
निकाल दो, कहाँ है?
Can GA2?
GA2.
Joyita Banerjee?
No, my lord.
Lordship,
Shweta Banerjee.
Shweta. Yes. Yes, Mrs. Mukherjee.
Lordship, I tell your lordship. First thing, your lordship, the appellant who is before your lordship, the appellant before your lordship was Prashun Bhattacharya.
Yes.
During the pendency of this appeal, your lordship, he passed away.
Yes.
So I have filed an application for substitution of Prashun
Correct.
Bhattacharya GA2.
No problem. We'll substitute his legal heirs.
Now, lordship, next thing is the original judgment, your lordship, the impugned judgment retains the name of Shweta.
The judgment may retain, Ms.
Yes.
Mukherjee, what your learned friend is saying, executing court. Executing court.
Executing court.
Yes, so that would be after the judgment.
No, my lord.
I
Prior
tell
to
your
the
lordship
judgment.
what has happened in
Prior
this
to
matter.
judgment.
If your lordship takes the appeal, memo of appeal, there is no name of Shweta Banerjee is appearing, but in the substitution application, it is
How
appearing.
could that be? Look at your own memorandum. Thou memota thou. You can't change the memo cause title.
No.
Yes, he's right. There's no Shweta Banerjee.
This is a technical error, your lordship. I'll take liberty to change.
Change.
Lordship, there's another thing.
My lord,
Putting
my
the-
lord, I am appearing in person, defendant number 1B. May I submit, my lord, one thing?
Yes.
Lordship, there's another.
Sir, please come and appear. We find it very difficult to hear you virtually.
नहीं है, तो इसमें हम लोग क्या है?
Do you not stay in Calcutta?
No, my lord. I am in Calcutta. Today I am not well. As such, I didn't visit the court, my lord.
Very well. Then come day after tomorrow.
No, my lord. Tomorrow, yes, my lord. Day after tomorrow, there is case in the also in the executing court. But only, my lord, may I draw your lordship's kind attention, my lord? Only
Yes.
one thing.
Yes.
In the suit, my lord, name of Shweta Banerjee is there.
Yes.
They did not pray for deletion from the suit.
Yes.
That is there. In fact, the execution case was filed in the arising out of the suit. If your lordship kindly sees the execution petition, CS3 of 2005 is there.
Yes.
Now they didn't take step in the suit to delete the name of Shweta Banerjee. Now suit is pending or disposed of because that issue is also raised by the plaintiff, that the as if the suit was disposed of, but no date of disposal has been given by them, any details. Now, after an order was passed on 21st June 2019, the name of the heirs of the original three parties were added in the suit, as well as in the execution case. There are two execution cases. So for that reason, my lord, Shweta Banerjee name perhaps has been given by the appellant. Now this part, we have prayed before the learned executing court, honorable executing court, that this suit has to be listed what it used to be listed before the all honorable judges, before the all honorable judges. But they are refusing to get enlist this matter. So
Very
I
well.
leave it to Lordship.
Yes, once you come, we will, yes, Ms. Mukherjee.
Lordship, there's another issue. Lordship, during the pendency of the appeal, one more degree holder respondent, Anandita Chatterjee, has also passed away. Lordship, I could not take steps for bringing her on record because the appellant himself had passed away. Until the appellant is not substituted, they could not take steps. The other thing is, Your Lordship, it will be, I leave it to Your Lordship. Anandita Chatterjee has been substituted in the execution code. So will it be Your Lordship's directions upon me to file another application?
Yes, you have to.
I'll do that.
Have to.
So Lordship will kindly take up this
We'll
matter.
adjourn this. Yes, we'll adjourn till the
It will
20th.
be upon me to take steps to bring
Hey,
Anandita
Lekho.
Chatterjee on record and to correct this.
There appears to be now the appellant Proshun Kumar Bhattacharya, the appellant, Proshun Kumar Bhattacharya, has passed away during the pendency of the appeal. Stop. An application has been taken out on behalf of his legal heirs who wish to come on record in the place and stead of their deceased father.
And husband.
Acha, deceased. Sorry, the place and state of the deceased. Stop. There appears to be a technical defect in the cause title of the substitution application. Stop. Liberty is granted to learned advocate on record for the applicants to take appropriate remedial measures. Paragraph, we are also told that the decree holder,
Lordship, it's a partition.
that
Parties are decree holders.
one of the respondents,
Anandita Bhattacharya,
Srimati Anindita Chatterjee, has also passed away. Stop. The applicants will be at liberty to take appropriate steps in that regard. Paragraph lists this matter once again on June 26, 2025. Stop. If in the meantime, any other application is filed by any of the parties, the same shall be listed along with the appeal.
Lordship, I'm grateful, Your Lordship.
Grateful to you.
Okay.
Item number 8.
But I appear for the respondent number 1.
My lord, in this matter, by an order of 23rd of April, my lord was pleased to, my lord, admit the appeal and had directed that notice of appeal be given to respondent numbers 2, 3, and 4. Respondent number 1 had appeared and the service was waived. Now, my lord, we have attempted service on the respondent numbers 2, 3, and 4, out of which, my lord, 2 and 4 have been served. But, my lord, so far as 3 is concerned, it has come back with the endorsement that addressee left without instructions. So we were unable to serve 3. Now, only thing, my lord, the actual contesting parties are, my lord, the appellant and the respondent number 1. Even if my lord sees the plaint, the defendant numbers 2, 3, and 4 have been described as pro forma defendants. So if my lord wants us to serve, we can serve once again. Otherwise, my lord may.
Mr. Swarnendu Ghosh is reading you.
Yes, my lord.
Informal paper books.
Yes, my lord.
Filed.
Served, my lord. Yes, I believe so. Yes. File any?
No relief claimed against the other defendants.
No, my lord. If my lord kindly just see.
No, Mr. Mukherjee, your word is enough.
Yes, my lord. They were added as pro forma defendants.
Very well. Then we'll proceed. We can proceed then.
My lord, kindly fixes a date for hearing of it, because we didn't know.
What you didn't know?
Well, because we were suspecting, my lord, that.
Are we filing any affidavit of service?
Yes,
today?
my lord. We had handed over the affidavit of service.
From the Kota DH affidavit of service, Dukhana. From the affidavits of service filed in court today, Riksho. It appears that the respondent numbers 2 and 4 have been served. Stop. The respondent number 3 could not be served, as apparently he has moved from the last known address without leaving any instruction. Paragraph. We would like to proceed with the appeal as the respondent numbers 2, 3, and 4 were pro forma defendants in the suit, and no relief has been claimed against them. Stop. The contesting defendant, being the respondent number 1 herein, is represented through learned counsel. Paragraph on the request made by learned advocate for the appellant, comma, let this matter stand adjourned and be listed again on
Any day after 1 week, my lord.
ইয়ে করো সামনের মঙ্গলবার আন্ডার দি অ্যাপ্রোপ্রিয়েট হেডিং। শুনুন, এটা অ্যাপিল হিয়ারিং হবে এবার।
But
item number 9.
Grateful to my lord.
Banerjee's
Oh, এই তো 9.
Your Lordship, Mr. Banerjee was making his submission. Your
Yes.
He is stuck in court number 4.
Yes,
he's
tell
on
us what
So
we
it
should
can
do.
be taken up not today and taken up
Yes,
tomorrow.
not today. You are in a hurry. We are not.
No, Your Lordship. We have almost completed. We'll just, Mr. Banerjee said he'll just take another
That's
15
all
minutes.
right. Point is every day counts because we remember you said the election is on the 3rd.
Right. July. 5th of July.
5th of July. Fine, not today. On the prayer for accommodation made on behalf of the appellant, comma, let this matter stand adjourned for the day.
Item number 10.
But I am appearing for the petition.
Appellant, yes, Mr. Ghosh.
My lord, before I take your lordship to the impugned judgment and order.
Only one respondent.
Only one respondent.
You are for the respondent.
Lord, I have a point of maintainability of the appeal, my lord.
What is that? Why is it not maintainable?
Because this order has been passed under section 74 of the Indian Trust Act. Two things over here, my lord. One, the Indian Trust Act, my lord, does not, my lord, authorize any person to make an appeal from this kind of an order. Secondly, this order has been made under a discretionary power of the Honorable Court, my lord. Now, the moment, my lord, an order is made, my lord, no right or prejudice is being caused, my lord, to the other trustees. No right of the trustees is decided, my lord. So therefore, my lord, there cannot be any appeal.
Very well.
My
Let
lord,
us
I'm
read
carrying two judgments. If required, my lord.
If required, cite it.
Yes.
Let us go through the order, Mr. Ghosh. That is what we do normally.
Kindly look at the order.
Yes.
And
You
and
take
to
your
be-
seat, we will go through the order.
Yes. Only if your lordship takes internal page 8 of the judgment and order, my lord.
No, let us go through the entire order. Yes. We have read it.
The only question before you
Do not open your case, Mr. Ghosh. 3:30 a matter has been fixed. But at least we know what the case.
I am happy because my learned friend has since taken the point of maintainability.
Yes.
I was not prepared, my lord. I will get some time to answer before your lordship.
Please share the citations of those two cases with you, Lord.
Definitely, definitely.
This appeal is directed against a judgment and order dated February 19, 2025, whereby the respondent's application being ATA 4 of 2023 has been disposed of by a learned judge of this court. Stop being aggrieved, before the learned single judge, you were respondent number?
They are the trustees, my lord.
All the trustees.
All the trustees. Acha.
Board of trustees.
Board of trustees.
Being aggrieved, the members of the board of trustees have come up by way of this appeal. Paragraph. Learned advocate for the respondent herein raises a point of maintainability of the appeal. Stop. He says that the order impugned having been passed under section
74 of the Indian Trust Act.
Indian Trust Act,
1882.
1882, the same is not appealable as there is no provision in the Indian Trust Act to that effect. Stop. Secondly, the learned single judge having exercised his lordship's discretion in a particular manner, which has not and could not have affected any vested right of the appellants, the present appeal cannot be maintained by them. Paragraph. Today there is no further time to Mr. Ghosh, Mr. Ghosh, learned senior counsel representing the appellants, has placed the impugned order before us. Stop. Today there is no further time to hear this matter. Paragraph. As requested by Mr. Ghosh, let this matter be listed again on
Thursday next.
Next week.
Thursday next. Today we are
Day after tomorrow. 26, June 26.
My lord, we have already filed a contempt application before the learned single judge. So, my lord,
now that we are hearing the appeal, do not proceed, sir. Do not proceed. We are not recording anything.
My lord, I am sorry, my lord. On 26th, I have a fixed matter.
24.
24. I'm extremely.
Commercial fixed matter, item number 2.
Wait, please, my lords.
You have a choice again, Mr. Bagh. This is a new bench.
My lord.
The other bench was hearing this. Either start afresh.
We'll start afresh, my lord.
Start afresh.
Very briefly, because, my lord, it is only 2 days, 5 minutes each day. So, my lord, we have not made any progress. My lord, I will start afresh and I'll try and, my lord.
The order
My lord.
of which violation is alleged was passed by?
This is not a violation.
This is not a contempt application?
No, my lord.
Oh, sorry.
Lord, and in my submission will be that, my lord, this matter is not linked to the contempt proceeding at all. And that's how I'll start, my lord. I'll indicate what the matter is. Sir, 5 minutes each.
Roughly how much time you will take, Mr. Bagh? We are not rushing you, just trying to assess. Half an hour.
My lord, 45 minutes to 1 hour, my lord.
Half an hour. You will respond today?
Yes.
So we can release the other matters.
Yes.
I'll keep it as brief as possible.
Even more brief than that.
I will not. That may I only indicate the issue here relates to a partnership firm which was formed on 1st October 2011.
Lord, only one thing I want to indicate, my lord, that we'll be taking, my lord, a preliminary objection as to maintainability of the appeal as well.
And why so? Indicate that. So
My lord,
that
section 13 of, my lord, commercial.
oh, this is a commercial code.
Partnership dispute.
May I, my lord? So this relates to.
Why don't you deal with the maintainability point first? Because if you can't answer that,
My lord.
why enter into merits? The appeal will be thrown out on that ground.
Lord,
Mr.
may I
Mukherjee did indicate this point on the last occasion.
My lord.
I remember that.
Yes, my lord. Kindly take up, my lord.
Commercial.
Lord, I thought the challenge on maintainability would be on another angle. So I was prepared on that angle.
And which is that angle that you thought?
There is an order in the proceeding where there is an observation that no steps can be taken for withdrawal of money from the accounts of the partnership firm. And I thought, that perhaps that will be indicated and it will be contended that this proceeding could not have been filed. So I have an answer to that. I'll come to that.
My lord, that is not, my lord, a question of jurisdiction, my lord, of entertaining. My lord, that's a point which we are going to take, because we are going to show, my lord, that there are orders, my lord, which are operating, which prevent, my lord, usage of funds. But, my lord, just to make this clear, my lord, I'll just cite section 13 and my learned friend, my lord, can deal with that. Kindly come to, my lord, section 13, my lord, of the Commercial Courts Act once.
Sorry.
My lord, kindly take, my lord, section 13 once. My lord, kindly come to 13(1)(a), my lord. Lordship has that, my lord. Any person aggrieved by the judgment or order of a commercial court at the level of a district judge exercising original civil jurisdiction, or as the case may be, commercial division of a high court, may appeal to the commercial appellate division of that high court within a period of 60 days from the date of the judgment or order. Now, my lord, kindly see the proviso. Provided that an appeal shall lie from such orders passed by a commercial division or a commercial court that are specifically enumerated under Order 43 of the Code of Civil Procedure as amended by this Act and Section 37 of the Arbitration and Conciliation Act, so and so. Then, my lord, 2. Notwithstanding anything contained in any other law for the time being in force or latest patent of a high court, no appeal shall lie from any order or decree of a commercial division or a commercial court otherwise than in accordance with the provisions of the Act. Here it's a suit. My lord, clause 15 will not apply. My learned friend has to show yes comes under order 43.
What is the order that is impugned?
My lord, order, my lord, is impugned, my lord, refusal to release money for his treatment.
May I, my lord? My lord, kindly take up the prayers that we have in IAGA 9, from which, my lord, this order, where, my lord, this order was passed. My lord, that's at page 47, volume 1. My lord, in this facts and circumstances, it is humbly prayed your lordships would graciously be pleased to pass the following orders. A. Order be passed directing the other respondents and plaintiff being partners of the firm to disburse a sum of this 2 crore 69 in favor of the petitioner as detailed in paragraph 20. Next prayer, my lord, B. My lord, I'll show this comes under order 40, my lord, 3 rule 1R. It is covered. My lord, kindly take up with, may I quickly show the other two prayers, my lord?
We have
Second
seen.
prayer.
We have seen.
My lord. Order 43 rule 1R, my lord. Under order 39 rule 1, 2, 2A, 4 and 10. It's a combination, my lord, of 1, 2 and 10. We fall under the proviso of 13(1)(a), my lord, and hence the appeal is maintainable. In fact, in a previous stage, my lord, there was an appeal from an interlocutory order which was considered by the Honorable Court and an order was passed. In fact, that is something I'll refer to.
One, 2, and 10 combination.
My lord. 10 because, my lord, I'll show from an order where, my lord, it was indicated that this is something they would give, this amount. And, my lord, all that we are praying for is, my lord, direction on them to furnish this sum of 2 crore 69 in favor of the petitioner as detailed in paragraph 20. I'll show what that pleading is. My lord, the difficulty is this sum, when seen in isolation, it may seem a lot. My lord, the dues we have shown from records that the dues to us is 667 crores. It's an admitted fact. I'll show from the records. In comparison thereto, my lord, whatever we are claiming, we are praying for the treatment of the petitioner, my lord, is this prayer. So, my lord, we fall under order 43, rule 1R. That is my very humble submission, my lord. And hence, the proviso to 13(1)(a) applies. That's my submission on the point of maintainability. Now, my lord, on the merits.
Mr. Bagh,
My lord.
if we are not with you on the point of maintainability, why will we hear you on merits?
If your lordship is not with me,
no, 1 to 10 in our reading, no.
Lordship, then may I only indicate this? Your lordship will kindly take up.
We are not concerned with how much money you are claiming, how much your dues is, whether it's poultry, peanuts, or nothing. We are not concerned. We are a question.
May I indicate what is this petition? If your lordship kindly takes up the premise of the petition, it starts from page 25 of volume 1.
Yes.
26 onwards, my lord, the first paragraph indicates why we have filed this. And I pause here for a moment, my lord, before I proceed any further. Lordship will kindly take up one order, which is, my lord, this application was filed, ad interim order was refused. From there, my lord, we have preferred an appeal. That appeal clarifies a lot of facts, my lord. Kindly take up that first, where I'll request you.
Now, the present order is an interim order, or
no, it's a final order.
Final order.
Final order, my lord. There was an interim order which was, my lord, refused. That interim order was refused, where we wanted, my lord, disbursal of funds. We preferred an appeal. My lord, kindly take up that appeal first. It's volume 4, page 591. From the same application, my lord.
That's an order passed in appeal preferred from refusal of interim order.
My lord. But volume 4, page 591 onwards.
Yes.
Lordship, kindly take up paragraph 2 at page 592.
Yes.
Paragraph 2, 592, my lord. In view of the arbitration clause, second paragraph, my lord, the dispute was referred to the Honorable Judge of High Court, in which an order was passed under Section 32 of the Arbitration Conciliation Act 1996. The Honorable Judge observed that the cause of action of termination proceedings accrued as this partnership is found, my lord, kindly mark this, is found to be a registered partnership at will, even on the basis of the statement of claim. However, Honorable Judge observed that what is prohibited under the arbitration clause is a prohibition upon the arbitrator not to award a dissolution of the firm, even if demanded by the partners who are constituting the partnership agreement. In this proceeding, after 13th of July 2019, there is no scope of passing any award of dissolution of the firm because all the partners ceased to be partners of the existing firm. I pause here for a moment. The legal right was recognized by the Honorable Court. In the sense, this observation was noted by the Honorable Court. There is no, I'm not going by the fact that this is an order under 32 of the Arbitration Conciliation Act. But this was the observation. This is because
32? What is 32?
Termination of the proceedings.
Termination.
Termination of the proceedings. Because of this clause. And may I only indicate what the clause exactly is? Lordship will kindly take up volume 13, page 1920. From the deed, I'll just indicate why this, my lord, could not be proceeded with. 1920, it's, my lord, volume 13.
You know what, in this kind of a case where you have 13, 15, 17 volumes. Yes.
We are carrying one. I didn't want to hand it over at the very outset, my lord.
Why? Because they save so much trouble.
May I
Yeah, we patla kota diye chole jabe.
My lord. This part is there. Extra copies. Yes. Page 12. Not page 12 of the compilation volume. Yeah. Clause 21. All the disputes and differences between partners. This is at the bottom of the page, is the pagination. It's page 12. Page 12,
Yes.
That all the disputes and differences between the partners arising out of and touching in respect of this partnership agreement shall be settled in arbitration. The arbitrator or arbitral tribunal as appointed and or constituted shall not have the power to award dissolution. This is the reason, my lord. Dissolution of the firm, even if demanded by the partners hereto constituting the partnership agreement, and save as above, such arbitration will be governed and conducted under the provisions of the Arbitration and Conciliation Act 1996. This is the reason, my lord, it could not be gone ahead with. Show me the order of this. Lord, may I? The order which I was referring to, my lord, it's from page 26, 28 onwards.
Division bench order.
Division bench order.
Page
The
20.
compilation volume, it's page 28 at the bottom, my lord, of the volume.
28.
Page 28.
Yes.
My lord, I was referring to paragraph 2 and 3. I've referred to paragraph 3, my lord.
Yes.
Then, my lord, paragraph 4, the partners of the original partnership firm also filed a suit for expulsion of the appellant. So, my lord, I stopped at paragraph 3, the middle. May I quickly indicate that the Honorable Judge observed that the cause of action of termination proceeding accrued as this paragraph 3, my lord, I'm referring to. This partnership is found to be a registered partnership at will, even on the basis of the statement of claim. However, the Honorable Judge observed that what is prohibited on the arbitration clause is a prohibition upon the arbitrator not to award dissolution of the firm, even if demanded by the partners, hereto constituting the partnership agreement. In the proceeding after 13 July 2019, there is no scope of passing any award of dissolution of the partnership firm because all the partners cease to be partners of any existing firm. I pause here for a moment. This date, my lord, 13 July 2019, is, my lord, when we issued a notice under section 43 of the Partnership Act. The Partnership at Will, we issued a notice for dissolution. There are 3 dates which are very important. 13 July, we dissolved, my lord, with that notice. 15th July, we were expelled. There is no firm, but by a notice, my lord, we were expelled. 17th July, 2 days later, there was a reconstitution of the firm. Now, this is, my lord, the genesis of the suit. The genesis of the suit, my lord, is the plaintiffs seek a declaration that this letter, this notice of 13 July 2019 is bad in law. Lord, our counterclaim in the proceeding is, Lord, the subsequent acts which are, my lord, which were barred in the arbitration proceeding. It's a partnership at will, and the subsequent acts is what we have prayed for, my lord, the resolution and the subsequent, my lord, steps. That's our counterclaim in the proceeding. This is what is pending adjudication. In the interregnum, my lord, we had filed one application which was GA2, GA1 and GA2, my lord. GA2 is filed by us, GA1 was filed by the plaintiffs. Some reliefs claimed for it is not really for money. What we had prayed for, I'll indicate that, my lord, from the order. What we had prayed for was essentially granted, except receiver. We had made a prayer for appointment of a receiver that was not granted. From there, we preferred an appeal. That appeal was heard by an honorable division bench of this court, where there was an observation which is very, very pertinent. That is the genesis of 50 lakhs disbursal to us. Because of the urgency, my lord, there was a direction that this amount will be, in fact, it is not a direction, more of a concession. Because the plaintiff stated that we are ready and willing to give this amount. So he said, then you give this amount and you settle this. And there are 2 observations which will come to. It's a 2-paragraph order, my lord, very, very relevant.
Justice Shonji Banerjee.
My lord. Your lordship was, my lord, part of that bench, and my lord, this order was delivered. Thereafter, my lord, I am not going into anything else. Because thereafter, my lord, comes the contempt angle, which is not really relevant. Why not relevant is this order, my lord. Now, this issue is settled. This amount is given to us by this order. And I'll indicate why. My lord, kindly take up the 4th paragraph onwards, my lord. It's at page 29 of the compilation volume, my lord. Partnership of the original partnership firm also filed a suit for expulsion of the appellant from the partnership and also a declaration that this is not a partnership at will. Defendant number 1 filed a counterclaim, inter alia praying for preliminary decree for dissolution with effect from July 13, 2019, followed by final decree in the alternative dissolution of the firm by the court. Arbitrator terminated the proceedings. Paragraph 7. But this is the order, my lord, of Justice, my lord, of 4th February 2020. This is, my lord, where those 2 GAs were being decided by the Honorable Court, where, my lord, the receiver was rejected. The prayer for appointment of a receiver was rejected. But this is paragraph 7. And then, my lord, an appeal is pending therefrom. That's paragraph 8. I'm not, my lord, troubling your lordship with the details of this. Paragraph 8. However, there is no order of stay. And this is, my lord, indicated, it's quoted, my lord, in the order at page 31 of the compilation volume. This is very important, my lord. Kindly permit me. This is the division bench order which I was referring to, my lord. The respondent number 2 and 3 have agreed to immediately release rupees 50 lakh in favor of Mr. Alam to facilitate his travel to Singapore for treatment. The respondent numbers 2 and 3 have also agreed that in addition to the same being released immediately, which will meet the expense for travel and the like, money will be directly paid to the hospital upon the hospital raising bills and without any delay. However, the respondent numbers 2 and 3 say The bills must be only pertaining to the treatment of Mr. Alam, his stay in the hospital and elsewhere in Singapore, and the incidental expenses pertaining to his wife will accompany him. The respondent numbers 2 and 3 have also agreed that Mr. Alam's travel by air ambulance to Singapore and expenses in such regard will be borne out of common funds. This was an agreement. Kindly see the later part. It is hoped that in view of this gesture, parties see reason upon Mr. Alam's treatment in Singapore being successful, parties would try and resolve the issues before the matter appears next on February so and so. It is made clear that payment to be released immediately and for medical expenses of Mr. Alam will be completely without prejudice to the rights and contentions. Agreed that upon final accounts being done, expenses incurred will be debited from entitlement, if any, of Mr. Alam. This is the premise, my lord. Now, why I read this out is, my lord, the first paragraph, there are two parts to the first paragraph. First part is, my lord, respondent numbers 2 and 3 have also agreed that in addition, that's the first part, my lord, that in addition to the same being released immediately, which will meet the expenses, money will be directly paid. So this is, the first part is 50 lakhs. And the second part is this, my lord, the respondent numbers 2 and 3 have also agreed that in addition to the same, so in addition to 50 lakhs, this amount will be paid immediately when the bills are raised by the hospital. This being noted, my lord, kindly take a paragraph 9, which is at page 32 of the convenience volume, my lord, over the page. March 9, 2021, coordinate bench directed the present appellant to file affidavits, detailed amounts of 50 lakhs. I will not trouble your lordship with the rest because, my lord, paragraph 10 says, in the course of hearing, we have been informed check was encashed by and is lying with the learned registrar original side. The next line is very important, my lord. This is paragraph 10 that I'm reading, my lord. Second line in paragraph 10. At the bottom of page 32, my lord. The appellant, showing grave urgency on account of medical treatment, filed an application before the learned single judge on 5th December 2024, in which on 11th December 2024, the impugned order was passed. This is the refusal of the ad interim order, my lord, ad interim prayer. In the said application, the plaintiff made a prayer for disbursal of 2,69,61 in favor of the appellant along with other remedies. The learned single judge declined to pass any ad interim order. After hearing the learned counsel for the parties, and learned single judge was of the opinion that in view of the disputed questions of fact, the prayer for ad interim relief is required to be decided on affidavits. Admittedly, the affidavits in opposition were not filed within time, and so this is the premise, my lord, of the appeal. The submissions are thereafter recorded, my lord, and not trouble your lordship. Kindly take a paragraph 17, my lord. It's page 36 of the convenience volume. And these 4 paragraphs are, my lord, the crux of the matter. My lord, kindly take a paragraph 17 onwards. We have been informed that the application for substitution of the legal heirs of respondent number 1 is pending before the learned single judge. This is fixed for hearing, my lord, on the 19th of this month, my lord. Paragraph 18. The basis of the application appears to be the prescription of 2 eminent doctors of Singapore, opinion of another specialist, Dr. Lalit Agarwal, on 3rd of December 2024, and the estimated cost for undergoing such treatment. Before the coordinate bench, the respondent numbers 2 and 3 have agreed to provide rupees 50 lakhs for the purpose of providing treatment, and on the basis of such assurance, the said amount was released in favor of the appellant on terms and conditions indicated in the order of 21st December 2020. But over the page, it is not in dispute. Paragraph 19. Paragraph 19.
Yes.
It is not in dispute that the said sum of rupees 50 lakhs is with the registrar original side and the said amount was invested. Neither of the parties have applied before the court for withdrawal or utilization of the said amount. This application has been filed now for utilization of the said amount along with other remedies. The requirement of the said amount for a medical treatment is prima facie established in view of several medical documents along with an estimate of the hospital where the kidney transplantation is likely to take place. Now that the said amount is lying with the learned registrar original side and the documents disclosed prima facie show that it involves substantial expenses to be incurred for the purpose of transplantation, and the doctors have advised that immediate steps are required to be taken for kidney transplantation, we are of the view that the amount lying with the learned registrar in terms of the order dated 21st April 2021, passed in APO so and so, shall be released forthwith along with the accrued interest in favor of the present appellant for the purpose of his medical treatment, and the said amount for the time being shall be treated as interest-free loan till the amounts are finalized. The failure, my lord, kindly note this, the failure to pass such interim relief would be fatal and irreversible. That's the premise, my lord, on which the order was passed. Lord, now kindly take up the next, Lord, next page. Para 24, my lord. It would be open for the parties to take exception to the report. This is the auditor's report, my lord, which has not been pending proceedings, and pray for appointment of an independent auditor and forensic audit if required. However, we emphasize that settlement of accounts should be done at the earliest to obviate all future complications. Any further order with regard to disbursement of further amounts to meet expenses for the medical treatment shall be considered by the learned judge in the pending proceeding. I pause here, my lord. This is what was considered and rejected. We make it clear that the learned single judge shall decide the matter uninfluenced by any observation. Needless to mention, suit file rejected this. This is the premise of the order, my lord. Now the impugn, this is why, Lord, I very humbly submit, because today, my lord, the urgency is that the appellant before your lordship, Lord, is awaiting a second transplant. And every day is a battle for the appellant. My lord, here kindly note.
We thought you were addressing us on maintainability.
Lord, on maintainability, my lord,
You finished whatever you said, that's all.
My lord, my submission, may I only indicate once.
Would you want some more time for considering the point? Because you said you were not prepared on this point.
On this point, my lord, since it was order 43 rule 1R, my lord, where I was, my lord.
That doesn't impress us. Neither order 43 1R doesn't impress us.
May I only, my lord, attempt this? Thereafter, my lord, if I'm required, I'll come back. The order 39 rule 10.
Deposit in court.
Deposit in court. And but thereafter, Lord,
withdrawal not covered.
Withdrawal.
Not covered.
But that, my lord, we always under we have that.
And that's in certain special circumstances, not for medical treatment, etc. Look at read Rule 10. We just read it.
Not sure.
Where there's an admitted claim and somebody says, I'm holding this in trust for him.
Right.
That's the language.
That's the language, my lord. Seen that. That's the language. So, my lord, here.
Here there was a gesture, Mr. Bagh, we remember. There was neither a mandate from the court.
My lord.
The court couldn't have mandated.
Court couldn't have. That is why, my lord, my
in fact,
failed.
that is exactly.
I understand that, my lord.
Yes.
So, my lord, today the premise is, while we submitted our notes, we have explained the accounts. My only endeavor before your lordships will be, my lord, to indicate from that interrelation of the accounts that we are entitled to 666 crores. So today, my lord, at this stage of the proceeding, my lord, if we are not, my lord, if this amount of 2 crores, my lord, in fact, there's an interim prayer which we have made in the state petition.
What happened to after this justice sentence order, that 50 lakhs you have withdrawn?
We have, my lord.
You have withdrawn.
It was somewhere around 49 lakh 50,000 after the disbursal, my lord. And then, my lord, I'll also indicate that the order impugned in the present proceeding, my lord, it goes on a premise that since this is not settled yet, the dispute, I am not in a position to direct for disbursement of this amount. So we had argued that with this entitlement, which is not in dispute, cannot be, from the accounts have shown that, and I'm ready to, my lord, indicate that from the records, that how this figure of 666.67 crores comes. My lord, it is something which is due to us. So, my lord, there are two options here. My lord,
but if I remember, they say that you have withdrawn much more.
We have not. And I indicate that. That's explained in our notes.
Obviously, your client will not admit that.
No, but I have.
But when you say undisputed, admitted, cannot be disputed, are you seriously using those words?
My lord, because of the accounts, I am. Because of the accounts. But I'll not indicate anything from what we have submitted. No. I'll only indicate the accounts, and the account speaks for itself, my lord. On that day, on 13th of July 2019, which is the cutoff date, On that day, my lord, we were entitled to a sum of 666.67 crores, and that is from the accounts.
Accounts finalized by?
Well, it's the accounts which are filed.
Filed.
Chartered accountants, my lord, it's
Right.
the audited
So
accounts.
they can't dispute it.
They can't dispute it.
So have you filed an application for judgment upon admission or 13A kind of an application where they can't have any defense?
The judgment upon admission, my lord, the premise in the suit is different.
13A?
But
Or there's something
today, my
akin
lord,
to
the
13A
premise
in
is, my lord, whether it's
Commercial
a
Courts
partnership
Act
at will,
also.
whether it's a partnership at will and what is the fallout thereof. Is the, my
You
lord,
don't have a
yes,
money claim in the suit?
no, we don't.
Oh,
my
you
lord.
don't have a
We
money
don't. So that is the reason, my lord, we can't file in judgment upon admission. And that is why, my lord, this petition by which we are trying to argue whether this is our entitlement. And I will only show from the record, nothing else. If your lordship is not, my lord, convinced or not with us, my lord, with the point of on the point of maintainability, kindly permit us to come back once. I'll try, my lord. If otherwise, my lord,
Try that.
I will.
We are, as of now, we are not with you.
Otherwise, my lord, on the merits, I'll clearly indicate, my lord, how we are entitled to this because, my lord, the clock is ticking for us. So if I know, my lord, that this appeal is not maintainable and I'm not able to, my lord, convince your lordships on that point.
You can try higher up.
Indeed, my lord, we will.
You can try higher up.
That's the reason, my lord. That's the reason. Because we had also made a prayer here, my lord, prayer E, in the stay petition, which is in the nature of an ad interim relief. Because, my lord, we know what is happening on a day-to-day basis. My lord, now he has to undergo, my lord, dialysis on a everyday basis. So, my lord, today, if this protection is not granted, the difficulty which we are facing is, my lord, we will not be able to fight another day. That's the entire premise. And that is why, my lord, if I'm not able to convince your lordships on the point of maintainability, my lord, I'll bow down. I'll try, my lord, and then I'll bow down. Kindly grant me a short, my lord, date. I'll come back.
Tell us when.
Friday.
Khata kholo.
My lord, may we come back on Friday, my lord, 20th?
Yes, you may. Oh, no, Friday, it will be a little difficult because this bench will be available only in the first half.
My lord, then Thursday, my lord, may we come back?
ফাঁকা আছে?
Thursday ওখানে আছো।
না না দেখে বলো ভাই। 19 3:30. Day after tomorrow 3:30. देखो Mr. Bagh, learned counsel representing the appellant. এই last দিনের অর্ডারটা দাও। Resumes his argument, but does not conclude. In particular, we would now on paragraph করুন. On the next date, we would request Mr. Bagh to address us on the point of maintainability of this appeal, since such a point has been raised by Mr. Mukherjee, learned senior counsel representing the
plaintiff number 3.
Plaintiff number 3. Plaintiff number 3. বলেছি কি ডেটটা বললাম না ডেট বলিনি ও প্যারাগ্রাফ লিস্ট দ্য ম্যাটার ওয়ান্স अगेन on June 19, 2025, marked 3:30 p.m.
Very deeply obliged, very deeply obliged.
বলছো কিছু
5 and 6 are also taking the point of mention.
আচ্ছা your point of as raised by Mr. Mukherjee, learned senior counsel representing plaintiff number 3, as also by Mr. Utpal Bose, learned senior counsel representing respondent numbers 5 and 6.